Yeah. ಟ್ಯಾಗ್ ಮಾಡಬೇಕು. ಫಸ್ಟ್ ಮ್ಯಾಟ್ ಇದು petition ಟ್ಯಾಗ್ ಮಾಡಬೇಕು. ಅದಕ್ಕೆ ಕೊಡ್ತೀನಿ. ಬಿಗ್ ಗ್ರೂಪ್ ಬರಬೇಕು. ನಂಗೆ ನೋಟಿಸ್ ಆಗಿದೆ. ಇಲ್ಲ ಡೇಟ್ ಇದೆ. ಅದನ್ನ ಇದೇ ಡೇಟ್ ತಗೊಂಡು ಅದನ್ನ ಜೊತೆಲಿ ಹಾಕ್ಸ್ಬೇಕು. ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವಾರ್ಡ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಬರೀ ಕೊಟ್ಟಿರೋ ಅದನ್ನ ಡಿಸೈನ್ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನ ಚಾಲೆಂಜ್ ಹೌದು. ನೋಟಿಸ್ ಆಗಿದೆ, ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೀನಿ. ಇದು ನಾನು ಟ್ಯಾಗ್ ಮಾಡಬೇಕು. ಎರಡು ಒಂದೇ ಸೇಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ. ತಗೊಳ್ಳಿ ಮೇಡಮ್. WP ನಮ್ದು 149 ಆ ನಂಬರ್ ಫಸ್ಟ್ ಮ್ಯಾಟ್.
ಅದು ಸ್ಟ್ರೈಕ್ ಮಾಡ್ತಿದೆ ಬರ್ತಿರ್ಲಿಲ್ಲ. ಆಗಿದೆ ಜಾಸ್ತಿ. ಇಲ್ಲಿ ಡಿಹೈಡ್ರೇಷನ್ ತರ ಆಗುತ್ತೆ. ಇದು ಚೇಂಜ್ ಆಗುತ್ತಲ್ಲ.
ಒಂದು ಸಾಲ three matters have to be connected in that matters. I've
Krishna has appeared for in the first matter.
Both the matters he's up. All the 5 matters, my lord, he himself appears. He had come in the morning. He's gone to the labor court, my lord. So he's told me to submit.
Go to labor.
Allah, submit ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಅಷ್ಟೇ. 3
list ಕೊಡಿ ಅದು.
Yes, my lord. I'll
submit that the above matters are connected to so and so registry is directly connect the same and relist on 14th March.
much of it. Serial number 26. I've seen that as well.
26. The request of here. King constituted well.
Serial number 33. Serial number 33.
Yes.
On the side.
In the section, Mr. BC Pravakar will have to take note. 33.1, you accept notice for the respondent?
33, my lord. 33, I am for the petitioner, my lord.
The first matter, second matter has been filed by Mr. Vijay.
Yes, ma'am.
I will accept notice, my lord.
Yes, accept notice.
Yes, my lord.
33.
My lord,
This for the respondent.
my lord, 32 and 41, my lord.
WP 49426 of 2012. Counsel for the petitioner shall have a copy of the petition along with annexes on said counsel. Objections, if any, by.
My lord, copy of this, lord.
Sir, his name is not just file Wakalas. Copy ಬಂದಿದೆಯಾ Mr. Subramania?
ಇದೆ.
Objections ಹಾಕಿದ್ದೀರಾ?
ಅಬ್ಜೆಕ್ಷನ್ ಇನ್ನೂ ಹಾಕಿಲ್ಲ.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
ನಾನು 1 week ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
2 weeks time.
Subramania, submit that he has already received copy of the petition along with annexure. He seeks for a week's time to file a statement of objection by 24th, rejoinder, if any, by 3rd, relist on 13th.
My lord, serial number 32, my lord.
Yes, really.
Serial number 32 and 41, my lord, pertaining to the same establishment. In both the cases, my lord, we have reached consensus for settlement. To file memo of settlement, my lord, we are working out modalities. Even K.S. Subramania is aware, my lord. We are seeking 2 weeks accommodation, my lord.
Both the councils they are working out the modalities of the settlement, and 2 weeks time is granted. They will report settlement. We will on 23rd at 2:30 p.m. under the caption reporting settlement.
32 and 41, my lord.
Yes, both.
Serial number 37.
Yes, madam.
Any date.
How are you feeling today?
I had to come for the strike matter only for 10 minutes, but some settlement in that case.
Respondent in
Yes, just a moment.
Otherwise, my lord, I have some dehydration and a bit of fever and fatigue.
Then we'll adjourn your matter. You take rest for this weekend.
Yes, ma'am. That's what I wanted to request, my lord.
Today.
Otherwise, I only came for the strike matter because some submission has to be made by the senior council.
We'll adjourn your matters. You take rest and Monday 30.
My lord. My lord, even now I can do it, my lord, but I've been advised not to take.
Take rest.
I think after 4 months, this is the first time, my lord, I experienced this. Otherwise, I was.
It happens. Weekend, please.
Yes,
Take rest.
I'll do that.
I have put it as an unrest.
Uh,
Subravadara Madbadi.
No, my lord, no. My lord, if I stay away from the court, I feel sick, my lord.
It was our forced rest or the other tonala 20th.
But my health is coming to court, my lord. I always maintain that.
But you also have to take rest. 37 in.
My lord, any date, my lord, after.
37 at the request.
respondent.
No. We list on 27th.
Yes,
24. Serial number 24.
24.
Yes, madam. I pay for my lord 2 weeks time.
Oh, yes. 24 at the request of the council for the petitioner. We list on 9th March. Interim order earlier granted to this meeting.
Your lordship, serial number 28 and 29, your lordship.
Madam,
Your lordship, I informed the other side. I need some time in this matter, your lordship.
28 at the request of the council.
28 and 29.
We list on 27th, 29 at the request of council for the petitioner. In WP 9011, we list on 27th.
Number 39.
Much obliged.
39 at the request of the Natraj Barral, released on 17.
serial number 38.
38 at the, please inform everybody.
Yes, ma'am. And my lord, I've requested Mr. Shekhar, my lord, to inform if I'm not here, my lord. Otherwise, I'll send him a message, sure, my lord. I'll send.
The request of council was, or we are bandilla and Bharat Bad. At the request of the council for the petitioner, we list on 28.
Page number 8, serial number 44 to 50.
46 and 57.
6 at the request of council for the petitioner, released on 28, 47 at the request of council for the petitioner, released on 28.
Page number 9, serial number 51 to 58.
51 at the request of the counsel for the respondent released on 28. 52 at the request of counsel for the petitioner released on 28. 55 at the request of counsel for the petitioner released on 2nd.
54, my lord. Next week, I.
At the request of counsel for the respondent released on 24th.
Page number 10,
56 at the request of counsel for respondent released on 2nd.
page number 10, serial number 59 to 67.
51, my lord.
60 and Mr. Peshwa.
60, my lord.
Mr. Peshwa.
Yes, sir. 60. Yeah, I'm appearing for that 60.1, 13798, your lordship.
I would be appearing or you would be appearing in this one?
Senior will be appearing in this matter, but I need to make a submission this now. The management of Rajiv Gandhi have refused employment to one of the workmen, your lordship.
We'll
Subsequently,
consider it when the matter reaches.
much
So
obliged,
once we have senior has to
much
appear,
obliged, your lordship. I'll do that, your lordship. I'll do.
61 at request of the counsel for the petitioner released on 10th March.
61.
10th March.
Page number 12, serial number 66 and 67.
Serial number 67, my lord.
Yes. Why, Dr. Srinivas?
My lord.
Why?
There's a connected matter. My lord, which has not-
No, we are connected.
ನಾವು ಎಲ್ಲ ಇದ್ರಲ್ಲೇ 427 of 2023 is Shakers has filed newly. Have to take.
67 done at the request of the counsel for the RTC released on 24th.
Stay has to be extended.
Interim order earlier granted is extended.
List number 2, page number 1, serial number 1 to 5.
At the request of counsel for petitioner released on 24th. Still number 2 at the request of the counsel for the RTC released on 10th March.
Till number 4.
4 at the request of the counsel for the petitioner released on. We'll have to issue notice to Mr. John D'Souza, I believe.
Yes, sir.
4. It is seen that the respondent is a party in person. Hence, the date would have to be communicated to the respondent. Registry is directed to issue notice to the respondent indicating the next date of hearing to be 27th March.
But, I also may be directed because he appears for the cases in the labor court, my lord.
He is
He
not
will also
appearing
take out
in
hands on
any matter is, none of the matters he has not appeared.
Mr. John D'Souza, my lord. He appears actively in the labor court, my lord. So, good, but picture it. He represents the workmen, my lord, in all.
Yes, sir.
I will be permitted to accept notice.
ಅವ್ರದ್ದೇ personal matter.
ಅದೇ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಅಂತ ನಾನು ಕೊಡಿ ಸರ್ ನಾನು ಕೊಡ್ತೇನೆ.
You inform me 27th.
My lord, I will also inform him officially.
Counsel for the petitioner is also permitted to inform. He is directed to inform the party in person about the next date.
Page number 2, serial number 6 to 16.
Serial number 6, my lord, I appear for the respondent in this matter.
Yes,
Kindly 2 weeks time may be granted.
from the petitioner.
And it's no, no, no. I am unaware of the.
Inform ಮಾಡಿದ್ರೆ
Please,
7 at the request of counsel for the respondent released on
6, my lord.
7 at the ನಿಮ್ದು adjournment.
Please, my lord, please.
My lord, I'm sorry, my lord, in second matter, in serial number 2,
One ನಿಮಿಷ 7 at the request of counsel for respondent released on 10th March. ಎಷ್ಟು ಏನು
likelihood of settlement, my lord.
ಯಾವತ್ತ
Second, my lord, on Thursday, my lord.
both the councils submit that there's a possibility of settlement if a short accommodation is granted, settlement will be reported, released on 16th February.
Serial number 7, 7 and 9.
7, 10th March. 9, the request of counsel for the respondent 10th March. 12, the request of the counsel for respondent 10th March. 16 at the council, at the request of the council for the RTC, released on 16th March.
Page number 3, serial number 17 to 20.
In serial number 19, it is a matter pertaining to Wonderla, madam. I appeal for the response.
19.
ಮಂಡಲ ಹಾಲಿಡೇಸ್ ತಾವು ತಗೊಳೋದಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಬೇರೆಯವ್ರಿಗೆ ಹಾಕಿ ಅಂತ ಕೇಳ್ತಾರೆ.
A bench of which SDRJ is not a part.
List number 1.
Only one request, my lord, 69, 70 matter, my lord, 230. 69 is the matter where I only have to argue on the quantum of punishment. Because for a person who had retired from service, my lord, Mr. V.S. Nayak case,
South March.
on a Tuesday, because Monday is trainee matters were posted, my lord. Otherwise,
69 at the request of the council for the RTC, released on 14 at 2:30 PM.
I'll inform Mr. V.S. Nayak.
I'm extremely sorry for my life. I'll reach little late, 34 in first list, my lords. That may also be called on 24th.
Swami ಅವ್ರಿಗೆ inform ಮಾಡಿದ್ದೀರಾ?
I'm ಮಾಡ್ತೀನಿ ನಾನು ಫೋನ್ ಮಾಡಿ.
34 at the request of the council for the released on 24.
Please. Serial number 38.
38 adjourn.
Your lordship, if I may submit, serial number 42, your lordship.
Just a
The
moment.
file is written.
Just a moment.
Yes.
38 ಅಲ್ಲಿ adjourn ಮಾಡಿದ್ವಿ.
ಅದು ಟ್ರೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಮಂಡೇ ಬರಲಿ ಸರ್.
Okay. 38 ಹೊಡೆದಾಕ್ಬಿಟ್ಟು. Sri L. Shekhar has entered appearance for respondent. Registry is directed to print his name as such and delete the name of Sri K. Srinivasa. Relist the matter on 13. Along with WP number
2248 of 20.
248 of 2021. Yes, madam.
Your lordship, serial number 42, your lordship. We have returned the file up. I appear for petitioner. So kindly give 2 weeks time so that they appoint a new counsel, your lordship.
You are in contact with the client?
Yes, your lordship. We have just returned the file to them
What
just 2 days back. So they want some time.
counsel on record is being designated as a senior counsel in order to enable the petitioner to appoint a new counsel. Released on 6th March.
Obliged, your lordship.
70.
70. 70 M.
Which are it?
70 when do you want it, madam?
14.
70 at the request of the council for the RTC, released on 14.
List number 1, fresh matter, serial number 1.
Lord, in this case, my lord, the employee will challenge the award in respect of non back wages and continue other consequential. The management is also prepared, my lord, petition in refresh number 5253. Similar, my lord, the award which has been challenged. I think
Who is
BK
appeared?
Prashant.
Who is appeared?
BK Prashant.
Shri BK Prashant is directed to accept notice for the respondent. Prashant BK. BK Prashant to Prashant BK. Out of difference.
Prashant BK.
Prashant BK is directed to accept notice.
I'll serve the court.
Connect the above matter with WP.
5253 award given.
5 so on. Objections, if any, by
8th.
objections, if any, by 24. Rejoinder, if any, by 3rd. Release on 9th.
Much.
Sorry, 10th.
Serial number 2, Prashant Ravi.
Sure, in this matter, madam. Yes, I appeal for the petitioner in this matter. Because there are 7 similar matter, my lords. They may kindly be connected. My lords, also the similar matter had already come up before this honorable court, my lords, in writ petition number 23875 of 22, my lords.
Audit copy you should do this.
The case of Matada, the petitioner has dismissed the respondent without holding inquiry. They have filed an application before the labor court approval of dismissal. So being the employer has filed application for ID for setters of dismissal order. Insofar as the petition, the respondent is concerned, ID is allowed. Insofar as approval is concerned, is dismissed. They prefer the writ. In this writ has been said subject to result of 17B. Matter will be listed for 20th of this month.
It is listed on 20th.
So we just direct connect other matter with give the release conference. Operation of the order dated 28/9/2022. Passed by the Industrial Tribunal Bangalore in SLA number 517 of 2014. In ID number 191 of 2014 as mentioned. Each stayed until the next date of hearing, subject to the petitioner making payment of 17B wages to the respondent.
Please.
Number 3. K.R. Anand. Copy not served.
Krishna Reddy. None appears for the respondent. Office objections have not been complied. If that office objection not complied by next date, the statement of objection would be liable to be rejected. Relist on 6th March.
Serial number 4. L. Shekhar.
And counsel for the petitioner submit that you would be making, you would be doing a needful. KSRTC. KSRTC yellow process at Westmont. The BL Sanjeev accepts notice for response. Counsel for the petitioner to serve a copy of the petition along with annexes on the said counsel. Objections by 24, rejoinder if any by 10, relist on 16.
Serial number 5. D.L. Sanjeev.
See, Basuraj appeared in the High Court.
Ministry MC Basuraj had appeared before the labor court. In that
Authority tribunal.
MC Basuraj accepts notice for respondent. Counsel for the petitioner to serve copy so and so. Obtained by same.
Serial number 6. Government student. 6th time. 7 office objections. 6th time.
No, serial number 6, I appear for the petitioner. There's a week's time may be granted. Finally, minutes I'll comply with everything.
On cost 6 times it has come up.
I apologize, minutes. I have it complied with within a week's time. Minutes as a last chance. It may be.
On cost, we'll impose cost. We'll give you a week's time. If you don't do it, we'll dismiss it.
Lordship may grant me one final opportunity. Minutes.
We will give you, but on cost. The matter is listed before this court for 6 times for compliance with the office objection, despite that the compliance has not been made. That counsel for the petitioner seeks for one more opportunity to do the needful. Though no such indulgence is required to be extended, one last opportunity is granted in the interest of justice, subject to payment of ₹5,000, which shall be paid to the advocate's library fund. Compliance to be made on or before 17th February.
Very well, much. I'll have it complied.
The petition would be liable to dismiss for non-prosecution. List on 21st.
I'm grateful.
Serial number 7. Naveen Kumar. N. Ramakrishna. Tumkur Court.
Private party na?
Private party.
Yaar apne na?
N. Ramakrishna before Tumkur Court.
Shekhar. Tumkur Court ali N. Ramakrishna. Yaar? Nobody. Notice of Bata. What is it? And you don't know. And some other don't know. That's on me. Tumkur Court.
N. Ramakrishna, advocate party Hesru Mukunda.
None appears for the petitioner if process fee is not paid and compliance of office objection is not made. By 17th, the petition will be liable to dismiss for non-prosecution, relist on 23rd.
Serial number 8, Rudrapapi.
Only 1 week timing.
LS Manjunatha, Advocates Mysore.
Comply the only 1 week timing granted to comply the office objections. In the meantime, notice has been issued. After complaints only, I will
Mr. Shekhar,
register the PF.
LS Manjunatha, advocate myself.
Mistaken, my lord.
Karnataka Silk Enterprises Corporation.
Be no more, my lord.
Who is the counterpart?
Less Manjunatha, I think is no more, my lord.
LS Manjunatha, Mysore.
Karnataka Silk Enterprises Corporation Limited.
Notice may have.
Counsel for the petitioner submit the.
No, my lord. After complaints of the office objections, I will furnish the process. Only 1 week
For
time.
the petitioner seeks for and is granted a week's time to comply with the office objection and thereafter make.
Please, please.
If needful is done, registry is directed to issue notice to the respondent returnable by 28th March.
But in fact, permission has not been given to comply, my lord, because the matter is in the file is in the pending branch. My lord. That is the problem. Because notice has been issued, my lord. File is in pending only.
Registry to.
Two branch.
Registry to permit the counsel for the petitioner to comply.
Oblige.
Serial number 9, MC Basuraju.
Counsel for the petitioner seeks for and is granted 10 days time to comply with the office objection released on 6th March.
This is covered, my lord.
In covered. Madam, ನೀವು ಇನ್ನ ಇಲ್ಲೇ ಇದ್ದೀರಾ? ಮನೆಗೆ ಹೋಗು ಅಂತ ಹೇಳಿಲ್ಲ. Covered ಅಂತ ಹೇಳಿ. Covered ಅಂತ 9.
Minor punishment.
That counsel for the petition seeks for and is granted 10 days time to comply with the office objection. Released on 27th. ಯಾವ್ದು covered ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ. ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ covered ಅಂತ ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸರ್.
Serial number 10.
ಎಷ್ಟೋ ಮ್ಯಾಟರ್ ಇದಾವೆ ಯಾವ್ದ್ರಲ್ಲಿ ಅಂತ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಎಸ್ ಮತ್ತೆ ಪ್ರೋಸೆಸ್ ಫೀ ಗವರ್ಮೆಂಟ್ ಡಿಲೇ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಪ್ರೋಸೆಸ್ ಫೀ ಸಮಥಿಂಗ್ ಒಂದು ಇಂಟ್ರೆಸ್ಟ್ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಒಂದು 10 ಲಕ್ಷ ರೂಪಾಯಿ ಹಾಕ್ಬಿಡಿ ಎಲ್ಲಾ ಕೇಸಸ್ ಪ್ರೋಸೆಸ್ ಫೀ ಹೋಗುತ್ತೆ ನೀವು ಕೇಳೋದೇ ಬೇಡ. ಇಲ್ಲ ಫಾರ್ ಗವರ್ಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಪ್ರೋಸೆಸ್ ಫೀ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಬಿ ಪೇಡ್. ಹಿಂಗೆ ಬರೋದಲ್ಲ ಅದು ಸೇಮ್. AGS seeks for and is granted 10 days time to make payment of necessary process fee. If needful is done, registry is directed to issue notice to respond number 2 and 3. ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು 2 and 3 ಗೆ?
Government advocate. Payment of cash.
Private.
K. Govindraj is appeared for respond number 1. R2 and R3 are labor officer and authority, assistant labor commissioner. Respond number 2 and 3 is dispensed with.
Number 1.
The submission of learned counsel for learned AGA, notice to respond number 2 and 3 is dispensed with. None appears for the respondent. Objections, if any, to be filed on or before 24th, rejoined if any by 10th, relist on 17th.
Serial number 11, BL Sanjeev. Copy of the dismissal order dated so and so.
Copy na certified copy.
Copy of dismissal.
Copy ne ಕೊಟ್ಟಿಲ್ಲ.
So ನನ್ನ petition ಹಾಕಿದ್ದೀನಿ ಸರ್ ನಾನು 350.
Counsel for the petitioner seeks for 1 week's time to comply with office of registries that connect the above matter with
356/23.
WP 356/23 and relist on 28. ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
What is it?
Same order earlier granted is extended till next week.
Serial number 12, Shubha Ananthi.
Yes, Ms. Mohan Kumar.
We'll take steps forward.
Who are R3 and R4? Yaru R.
Private parties.
Right. But we have served the copy to the respondent council, but they have not filed wakalat. I will anyhow, I will take.
Labor court ಅಲ್ಲಿ ಯಾರು appear ಆಗಿದ್ರು?
TJV ಅಂತ.
ಯಾವ labor court?
ಇದು ರಾಮನಗರ.
Shekhar. Ramnagara, Sridevi advocate.
ಶ್ರೀದೇವಿ ಅವರು ಇಲ್ಲೇ ಬೆಂಗಳೂರಲ್ಲೇ
ಅಲ್ಲ ಅವ್ರು ರೆಸ್ಪಾಂಡ್ ಮಾಡ್ತಾರೆ ಇದೆ.
ಅಪಿಯರ್ ಆಗಿದಾರಲ್ಲ
ಕೆಲವರಿಗೆ ಅಪೇರ್ ಇವರಿಬ್ಬರಿಗೆ ಅಪೇರ್ ಆಗಿಲ್ಲ. I will take one step to
the petitioner seeks for and is granted a week's time to make payment of necessary process fee. Needful is done. Registry directly issue notice to respond number 3 and 4 returnable by 30th March.
stay baby.
Interim order earlier granted.
Please.
13, DL Sanjeev.
Who is our one?
Here,
Kumar
ಕೇಳಿ ಅಲ್ಲಿ ಹಿಂದೆ ನೀವು ಇಲ್ಲೇ ಕೇಳ್ಕೊಂಡ್ಬೇಕು
ಅಲ್ಲ
ಶೇಖರ್ ಅವ್ರಿಗೆ ಬಿ ಎಸ್ ನಾಯಕ್ ಅವ್ರಿಗೆ ಸ್ವಾಮಿ ಅವ್ರು ಕೇಳಿದ್ರೆ ಇವ್ರು ಇದು ಒನ್ ಆಫ್ ಇಯರ್
This is the best option for us also, than sending peer process and time waste.
It gets delayed for 4 years for that reason. ಇಲ್ಲ ಪಕ್ಕದಲ್ಲೇ ಇಟ್ಕೊಂಡು Land counsel for the petitioner seeks for and is granted a week's time payment of process fee. Needful is done. Registry is directed to issue notice to respond number 1 returnable by 30th March.
Matters listed on 14-2.
14. Chair number 11, the connected matters on 14. 11, 14.
serial number 14, HR Renuka.
Time.
Who appears for the respondent?
Is expired.
They have raised the dispute. Who raised the dispute?
Well, it's a SMA matter. That is serial application is rejected.
Refuse to take note.
Endorsement has been put up that the respondent has refused to accept notice. Hence, service of notice in respect to response is held sufficient. Existing right to print their name. In the past list, the endorsement refused to accept notice. We list on 6th March. Interim order earlier granted is extended.
Serial number 15, government advocate.
Who are R1 to R5?
R1 to R5, private system.
ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅವ್ರಿಗೆ
Khadar Pasha,
ಇಲ್ಲಿ ಖಾದರ್ ಪಾಷಾ
Bengaluru.
ಶೇಖರ್ ಖಾದರ್ ಪಾಷಾ ಗೊತ್ತಿಲ್ಲ ಈಗ ಯಾವ್ದೂನು ಇವತ್ತು
ಅಧ್ಯಕ್ಷರು ಸರ್ಕಾರಿ ದಿನಗೂಲಿ ನೌಕರರ ಜಿಲ್ಲಾ ಘಟಕ ಕೋಲಾರ. ರೆಪ್ರೆಸೆಂಟೇಟಿವ್
ಕೋಲಾರ ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾರಲ್ಲ
ನಾನು ಹೋಗ್ತೀನಿ ಬಟ್
ನೀವು ಹೋಗ್ತಿರಲ್ಲ ಕೋಲಾರ And it is submitted the procedure has been registry directed to issue notice to respond number 1 to 5 returnable by 30th March.
serial number 16, Girish B. Bandare, connected matters.
is making kindly pass on.
Serial number 17, Hrishikesh Madhav. Harvard.
registry is looked up and note that it is the Dharwad bench of this court which would have been territorial jurisdiction. In view thereof, the registry is directed to transfer the above petition to Dharwad for being needful. For the whatever statistics, the other petition is deemed to have been disposed before this.
Serial number 18. Chandrasekhar.
Yesterday, after filing my lord, I have served to the Devraj advocate, 1120 CR.
But
Preliminary hearing movement.
nature of petitioner to which he is not forthcoming. Of BESCOM, the H.V. Devraj confirms receipt of the petition along with annexures and the office notation at CL number 2 does not survive for consideration. Nature of petitioner names.
Nature of petition is the additional bill demanded by the
nature of the petitioner is a company, na?
company. Yes. It's an admitted fact.
Counsel for the petitioners admitted in the very well aspect level. Company incorporated under the Indian Companies Act 1966 having a raised document. Learned counsel for the petitioner seeks for and is granted a week's time to comply with office of petition CL number 1.
But running page number annex 13, annex A. May I permit to read my lord Mane from there. ವಿಷಯ ಎಸ್ ಅಂಡ್ ಸೊ ವಿದ್ಯುತ್ ಜಕಾತಿ ಕಂದಾಯ ಕೊರತೆ ಮೊತ್ತವನ್ನು ಪಾವತಿಸುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರು ಬಿ ಮಾಪಕ ತಪಾಸಣಾ ಉಪವಿಭಾಗ ಬೆಂಗಳೂರು ವಿದ್ಯುತ್ ಕಂಪನಿ ಅವರ ವರದಿ ದಿನಾಂಕ 15/12/2012 ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೇಲ್ಕಾಣಿಸಿದ ಉಲ್ಲೇಖಿತ ಪತ್ರದ ಅನ್ವಯ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರು ಬಿ ಮಾಪಕ ತಪಾಸಣಾ ಉಪವಿಭಾಗ ಬೆಂಗಳೂರು ವಿದ್ಯುತ್ ಕಂಪನಿ HSR ಬಡಾವಣೆ ಬೆಂಗಳೂರು ಅವರು ದಿನಾಂಕ 15/12/2012 ವರದಿ ಅನ್ವಯ ತಮ್ಮ ವಿದ್ಯುತ್ ಸ್ಥಾವರದ ಸಂಖ್ಯೆ ಗೆ 17/12/2012 ಸಂಪರ್ಕ ನೀಡಿತು. ಸದರಿ ವರದಿ ಅನ್ವಯ ಮಾಪಕ ಗುಣಾಂಕವು 15 ಇರುತ್ತದೆ. ಆದರೆ ದಿನಾಂಕ 2/4/2019 ಮಾಪಕ ಬದಲಾವಣೆ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಮಾಪಕ ಗುಣಾಂಕ 10 ಎಂದು ತಪ್ಪಾಗಿ ನಮೂದಿತವಾಗಿರುವುದರಿಂದ ಪ್ರತಿ ಮಾಹೆಯಲ್ಲಿ ಕಡಿಮೆ ಬಳಕೆಯ ಯೂನಿಟ್ಗಳಿಗೆ ಬಿಲ್ಲನ್ನು ಜನೀಕೃತಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಬಿಟ್ಟು ಹೋಗಿರುವ ಯೂನಿಟ್ಗಳಿಗೆ ಸಾಮಾನ್ಯ ದರದಲ್ಲಿ ಕಂಪನಿಯ ನಿಬಂಧನೆ 29.03 ರ ನಿಯಮಾನುಸಾರ ಕಂದಾಯ ಕೊರತೆ ಮೊತ್ತವನ್ನು ಲೆಕ್ಕಾಚಾರ ಮಾಡಲಾಗಿರುತ್ತದೆ. ವಿವರಗಳು ಈ ಕೆಳಕಂಡ ಇರುತ್ತದೆ. This is the Melon tables. Then Melon last line after the table. ಕಂದಾಯ ಕೊರತೆ ಮೊತ್ತ ರೂಪಾಯಿ 15,01,663 ಗಳನ್ನು ಈ ಪತ್ರ ತಲುಪಿದ 30 ದಿನಗಳಲ್ಲಿ ಪಾವತಿಸುವುದು ತಪ್ಪಿದಲ್ಲಿ ಯಾವುದೇ ಮುನ್ಸೂಚನೆ ನೀಡದೆ ತಮ್ಮ ಸ್ಥಾವರದ ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ನಿಲುಗಡೆ ಮಾಡಲಾಗುತ್ತದೆ.
That the direct notice has been issued instead of issuing the provisional notice. It says that
But from 2012 to 19, you are not inspection.
That 2012 to 19 that there is a correctly that calculated constant 50.
So from 2019
onwards that is.
2019 you came to know that there is a change.
Yes.
From 19 why have you kept quiet till 22?
That is the meter constant calculating that it is so far that is.
Next month calculate ಮಾಡ್ಕೊಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ.
ಅದು instead of calculating constant 15 the 10 have calculated.
When did it come to your knowledge?
That is not that only in the periodical meters testing MT division inspected the meter. Then they have found so far that LT rate so far that the constant is in a 15. However, that it is a bills verified constant calculated 10. Therefore, that is a erroneous bill so far that short climate charge. Not in a computer. That meter reader while records the meter while raising a bill, it requires to multiply 15 times.
Meter reader idara inna?
Either.
Today everything is computerized. The bill comes on email.
The emails come only after reading the meter. He has to upload.
Reading nimde baratte. Okay. ಅದನ್ನು ಏನ್ ಫೆಸಿಲಿಟಿ ಇಲ್ವಾ?
Like ಈಗೇನೋ that trying to update it, that as equal that if the bills is not paid, notifying the date automatically for disconnection.
Can you not, since all these are electronic meters,
Yes, yes.
can these not be uploaded onto your system from the meter itself?
No, not yet upload, not yet.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
That now that work on progress, Mr. Government. That shortly that they will take that initiative.
These kind of human errors put them into trouble. ಅವ್ರು ಆರಾಮಾಗಿ ಕೊಡ್ತಾ ಇದ್ರು, ಇವಾಗ 15 ಲಕ್ಷ ಕೊಡ್ಬೇಕು.
Now therefore the 29(3) says that
6 lakhs I have
class
paid.
29(8) that where that is an erroneous entitled. The follow the procedure 29(3) that issue a provisional, but here that they make mistake directly directed to them pay. Now that the power supply has not been disconnected as on today, yesterday. Let there treat this as a show cause notice, let file an objections and we will consider in detail. So
The petitioner is before this court seeking for the following leave. The grievance of the petitioner is that a demand notice has been issued on 28 December 2020 without even calling upon the petitioner to show cause if such a demand could have been made and if the same is justified. The H.V. Devara, direct counsel for the respondent, would submit that the notice at Annexure A may be treated as show cause notice, with liberty being reserved to the petitioner to reply to the same within a period of
2 weeks or 10 days
2 weeks from today,
from the date of receipt of the order.
from the date of receipt of the order. Once such a reply is submitted, the same to be considered by respondent number
the respondent number 4.
4
Yes,
within a period of
within a period of 4 weeks that after giving opportunity to him.
4 weeks thereafter, after giving necessary opportunity of being heard to the petitioner.
Third respondent, sorry. Third respondent.
The petitioner is liberty to raise such documents as the petitioner relies upon till that date. Needless to say that no action can be taken in pursuance of Annexure A, which is being treated as show cause notice. That is stand dismissed.
Same order in second matter. ಅದು next unit. ಇವರು ಎಲ್ಲರಿಗೂ ಕೊಡ್ತಾ ಹೋಗ್ತಾರೆ. But humble request ಮೇಲೆ this additional supplement demand ಮೇಲೆ. So it's totally a time barred ಮೇಲೆ. Because from the day one the electricity we are not my lord sincere consumer and my lord we are supplying the my lord Indian army for the my lord that ಸಿಯಾಂಚಿಗಲ್ಲ ಅದು ಬಾಕ್ಸ್ ಕಳಿಸಬೇಕಾದ್ರೆ ಡೀಸೆಲ್ -0 -4 ಅಲ್ಲ ಹೋದಾಗ ಅದು ಕೋಲ್ಡ್ ಆಗಿ ಇದಾಗ್ತದೆ, ಗಟ್ಟಿ ಆಗ್ತದೆ ಡೀಸೆಲ್. ಅದ್ರದ್ದು ಬಾಡಿ ಮಾಡುವಂತ ಆಥರೈಸ್ಡ್ ಕಂಪನಿ ಅವರಿಗೆ ಹೋಗಿ ₹1 ಅವ್ರದ್ದು ಅರಿಯರ್ಸ್ ಬಿಲ್ಸ್ ಇಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ಸಿಸ್ಟಮೆಟಿಕ್ ಆಗಿ ಕಟ್ಕೊಂಡು ಫ್ರಮ್ 2012 ಇಂದ ಬಂದಿದೆ. ಇವತ್ತಿನ ನೋ ಮಿಸ್ಟೇಕ್ ಇಲ್ಲ ಫ್ರಮ್ ಅವರ್ ಸೈಡ್. ಸಡನ್ ಆಗಿ ಬರ್ತಾರೆ ಇಷ್ಟು ಬಿಲ್ ಕೊಟ್ಟು. Yes, man. But
done. But you will have to look at
That I instructed yesterday itself that we should not do this so far as that is concerned. And also write a letter to the GM also, because of it requires to be so far as that agitate so far all the officers. This should not be an happen so far as that because of that.
ಮೀಟರ್ಗೂ ನಾವೇ ಬಿಲ್ ಕೊಡೋದು, ಅದು ಇನ್ಸ್ಟಾಲ್ ಮಾಡೋದು ನಾವೇ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ.
technology is available. That Internet of Things, IoT technologies are available.
ನೋಡಿ
ನೀವು ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ನಿಮ್ ಫ್ರಿಡ್ಜ್ ನ ಕಂಟ್ರೋಲ್ ಮಾಡಬಹುದು.
That is
So meter reading can automatically be uploaded without human error.
yes. That it is once that it is an updated automatically it will separate all that.
You can make it optional
Yes, yes.
to the subscriber. And if he wants to avail that service, he pays a little extra.
Yes, yes.
It's an option. Can't make it compulsory. But most of the people would want to do this to avoid this kind of issue.
Yes, ma'am.
Sudden ಆಗಿ ನೀವು 15 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರಿಗೆ for any businessman or any consumer ಎಷ್ಟು ಪ್ರೆಷರ್ ಆಗುತ್ತೆ, ಎಷ್ಟು ಟೆನ್ಷನ್ ಆಗುತ್ತೆ.
Lord, we are not purchasing this meter. They only installing after necessary payment. We don't have any option. They are the ultimate authority.
They are just saying it is their mistake only. That their meter reader has made an entry of 10 constant instead of 15 constant.
ಈಗ ಹೇಗಂದ್ರೆ ಸ್ವಾಮಿ ಟ್ರಾಫಿಕ್ ಅಲ್ಲಿ ನಾನು ವೈಲೆಂಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ನಂಬರ್ ಹಾಕಿದ ಕೂಡ ಅಲ್ಲೇ ತೋರಿಸ್ಬಿಡುತ್ತೆ. ಕ್ಲರ್ಕಿ ಹಾಗೆ ಹೇಳಿದಂತೆ ಫ್ರೀಡಮ್ ಪಾರ್ಕ್ ಅಲ್ಲಿ ನೋಡಿ ಇಷ್ಟು ಇದೆ ಕಟ್ಟಿ ಬಿಡಿ ಇಮಿಡಿಯೇಟ್ ನಾಳೆ ಒಳಗೆ ಅಂತ ಹೇಳಿ.
The 50%
Yes,
discount.
So,
will be-
ನಾಳೆ ತನಕ ಇದೆ.
by honorable committee chairman, our honorable.
There's a 50% discount sale going on.
Just I brought to notice.
1,47,000 cases have been disposed. 1,47,000 cases in 1 week.
ನಾಳೆ ತನಕ ಕಾಯ್ದೆ.
Drastic step.
State has recovered more than 15 crores in 1 week.
Yes. Drastic steps has been taken.
Mujagoda is very happy. Or his client is very happy.
Our chairman, honorable chairman has taken very serious steps. Drastic step. It's a big mileage for us.
Everybody can use it.
Yes.
We are 1,47,000 cases could be disposed in 1 week. And it's a
ಮಾಡ್ಬೋದು ಇವ್ರಿಗೆ ಮೀಟರ್ಗಳನ್ನು.
idea ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Sorry.
Now also, we are also suggesting all those things, sir. Because very difficult so far that even manpower, all these things is in order to avoid.
We are not deciding it now.
Yes.
We are not authorized to decide on it. But if you look at your demand,
Yes.
you are levying a penalty. You are levying interest,
Tax.
and tax.
The tax automatically, consumption tax, it will come so that is.
Penalty.
On items, it is a mistake of your meter man.
Yes.
Penalty is
Unless
55,000.
you are able to show that there is a collusion between them and it was a fraudulent reading, why should they be responsible? They are if they are bona fide, they should not be.
That is the why that separately wing which has been so far that meters testing division is there, periodical testing. That has to be done with yearly to that once in 2 years. That also in doing. This is that.
The blockchain and the technology which are available, which are multi-ledger, which will do everything and give it to you.
Yes.
This kind of things will not happen.
Yes, yes.
Already
Suggestions are made and progress is going on. The infrastructure is more, the government has to agree all these things. It is under progress.
Subscriber consumer will also pay that cost. It won't be too much. It may be 500 rupees or so, or 1,000. He will pay for 10 minutes.
ಅಲ್ಲ ಇದು ನನ್ನ ಪೆನಾಲ್ಟಿ 55,000 for no cause. Penalty 55. Tax. Please, I will same order.
Much.
Oblige madam. Deeply oblige.
Objections are ಹೇಳಿ ಇದೆಲ್ಲ ಹೇಳಿ ಇಂತ ಮೀಟ್ ನಾವು ದುಡ್ಡು ಕೊಡ್ತೀವಿ ಅಂತ.
I will follow your law. Grateful.
Open to him for all that objections as well as suggestions also.
Suggestions are ಕೊಡಿ.
Please.
Consumers give suggestions, then they can accept.
Please. Oblige.
Hearing on IS, serial number 20. Nandakishore.
Petitioner, my lords. The respondent workman has made an application under 17B. Since he has already been appointed by us and employment as per the earlier directions issued by the honorable courts, section 17B application may not survive.
Yes, madam.
I'm appearing for the respondent, Your Lordship.
So has the respondent been given employment and reinstated?
Kindly pass over the matter. Senior is engaged in a different court.
So we'll get to know, you will get a order.
Yes.
Where will you go? You are but in India, Allah.
Allah, my humble submission. I have personal inconvenience.
You are not required.
Yes.
They make the submission. We'll pass.
Much obliged.
21. DL Sanjeev.
ಅಲ್ಲಿ ವೆಂಕಟೇಶ್ ಕುಮಾರ್
ನೀವು ತಗೊಳ್ತೀರಾ?
ಅಲ್ಲ ಅವರೇ ತಗೋತಾರೆ ಫೋನ್ ಮಾಡಿದ್ದೆ.
Bhupesh Kumar accepts notice for respondent. Umbrella. For LRs of the deceased respondent.
LRs ಒಬ್ರೆ.
He submits that he has no objection for allowing IA 1, 2 and 3 of 2022 which have been filed to bring the legal representatives of deceased respondent on record. Accepting the reasons stated in support of IA 1 of 2022, delay of 144 days is continued. Consequently, abatement is set aside by allowing IA 2 of 2022. IA 3 of 2022 is allowed by the person named therein are brought on record as respondent 182C. Counsel for the petitioner to carry out necessary amendment, file amended cost title, relist on objections, if any, by 3rd March. Adjourned if any by 17th, relist on 24th.
Serial number 22, Harish Bhandari.
Present is Your Worship, to stay the proceedings before the magistrate.
Shankarappa,
What had happened, Your Worship? Respondent workman by order dated 5/1/2019. Labor Court directed to reinstate on 5/1/2021. And we have filed the writ petition, and this honorable court has passed the interim order on 7/6/2022.
prosecution at 25.
29 only.
29.
29 of the Aid Act, he has sought for prosecution, and then now the prosecution has been taken place. That I wanted to.
Learned counsel for the, none appears for the respondent. Learned counsel for the petitioner submits that the petitioner has reinstated the respondent workman on
Reinstated, Your Worship, on 7/6/2022 as the interim order granted, Your Worship.
ಯಾವ reinstatement?
7/3/2022.
7/3/2022 you are reinstated
Yes.
before the order. Doubtful, Mr. Bhandari.
Vote on the source settlement respondent. Illa. 7/6/2022 is the interim order. Subsequently, we reinstated. He's working.
Subsequent to the order, there is 7/6.
Let me tell you.
He therefore submits that there would not be a need that the prosecution initiated in terms of section 29 of the ID Act may be stayed. Accepting the said submission, IA 1 of 73 is allowed. The prosecution of the petitioner in CC
Your Lordship has reported on 8/7/2022.
CC number 11119 of 2020. Pending before the 6th ACM in Bangalore City. He stayed till the next date of hearing. Subsequent to the order dated 7/6/2022 on
8/7/2022, he reported the truth.
14th March.
That was.
Serial number 23, 24, urgent, 25.
At the request of the counsel for the petitioner, relist on 27.
26 urgent, 27.
So Vijay Kumar.
Eight 29 urgent, 30.
Srinivasa.
Thirty-one. Devi Narayan Swami.
Appear for the respondent, the client has engaged the services of senior counsel V.S. Nayak. Request that it be passed over to the afternoon session, my lord.
Yes, sir. ಮಧ್ಯಾಹ್ನ ಇದೆ.
ನಮ್ ಕೆಲಸ ಏನಿಲ್ಲ.
ನಾನಿಲ್ಲ ಅಲ್ಲ ಕೇಸ್ ಅರ್ಜಿಯವರು ಎಲ್ಲ ಅಲ್ಲೇ ಇರ್ತಾರೆ, ಅದಕ್ಕೆ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಅರ್ಜೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡ್ರು ಆಲ್ರೆಡಿ.
ಬರೀ ರೇಣುಕಾ ಅವ್ರದ್ದು ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರು.
ರೇಣುಕಾ ಅವ್ರದ್ದೇನೆ ಎಲ್ಲಾನು ಕೇಸ್ ಅರ್ಜಿ.
ನೀವು ಅಲ್ಲೇ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ನಾನು ಹೋಗಲ್ಲ ಸರ್, ನಮ್ ಕಲಿಗೆ ಹೋಗ್ತಾರೆ.
V.S. ನಾಯಕ್ ಅವರು ಅಲ್ಲೇ ಹೋಗ್ತಾರೆ.
V.S. ನಾಯಕ್ ಅಲ್ಲೇ.
Sure, he'll come at 2:30.
My lord, I have.
ಇಲ್ಲ ಅವ್ರು ಮೀಟ್ ಮಾಡಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಪ್ರತಿ ಸಲ ಹಿಂಗ ಆಗ್ತೀವಿ. 5ನೇ ಸಲ ಸ್ವಾಮಿ ಇದು ಅಡ್ಜರ್ಮೆಂಟ್. 6ನೇ ಸಲ.
Last time he did submit that he would be appearing and you.
ಹೌದು, ಅದಕ್ಕೆ 4 ಸಲ ಮೊದಲು ಅವರೇ ಅಪಿಯರ್ ಹೇಳಿದ್ರು, ನಾನೇ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ, ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಅಂತ ಅವರೇ 5 ಸಲ ಟೈಮ್ ತಗೊಂಡು.
ಏನ್ ಮಾಡೋಣ?
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ವಲ್ಪ 2:30 ಅಂತ. ಸ್ಮಾಲ್ ಇದೇನಾಗಿದೆ ಅಂದ್ರೆ ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ಬಿಡ್ತೀನಿ ಸರ್. ಕಂಪನಿ ವಾಸ್ ಕ್ಲೋಸ್ಡ್ ಲಾಂಗ್ ಬ್ಯಾಕ್. ಅರ್ಲಿಯರ್ ಕಂಪನಿನ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಕ್ಲೋಜರ್ ಕೇಳಿದ್ರು. ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ದೇರ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಕ್ಲೋಜರ್. ಅಲ್ಲಿ ಆ ಡೇಟ್ ವರ್ಗು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರು ಅಮೌಂಟ್ಸ್ ನ ವರ್ಕರ್ಸ್ ಆಸ್ ಇಟ್ ಕಂಪನಿ ಇಸ್ ರನ್ನಿಂಗ್ ಅಂತ. ಮತ್ತೆ ಅದಾದ್ಮೇಲೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ರಿಜೆಕ್ಷನ್ ಹೈಕೋರ್ಟ್ ಬಂದ್ರು, ಹೈಕೋರ್ಟ್ ಇಂದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋದ್ರು, ಕೊನೆಗೆ ಫೈನಲಿ you make one more application for the closure until. Application subsequently after 4 years, that application was allowed. Up to that date, in the IF law, company continues to be. Adana now claim labor court red judicate modle you claim reject adರಲ್ಲಿ in the meanwhile ಏನಾದ್ರು negotiate ಮಾಡಿ settle ಮಾಡಿದ್ರು ಆಗುತ್ತೆ ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಕಂಪನಿ ಕ್ಲೋಸ್ ಆಗಿದೆ ಬಾಂಬೆನಲ್ಲಿ ಅದೇ ಕಂಪನಿ ನಡೀತಾ ಜೇಲ್ ಮಾರ್ಸನ್ ಅಂತ ಫೇಮಸ್ ಕಂಪನಿ ಅದರಿಂದ ಈ ವರ್ಕರ್ಸ್ ಗೆ ಕೊಟ್ರೆ
Follow the submissions.
My lord, we don't have instructions for negotiation. However, I can seek instructions, my lord, whether they're willing.
ಅದು ನಾಯಕಗೂ ಹೇಳಿದ್ದೆ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ 2 months back ನಾಯಕ ಹೇಳಿದೆ.
Instructing counsel has to instruct Mr. Nayak as to what is.
My lord, I'll seek instructions from the client as to whether they're willing to enter into these talks, my lord.
ಅದೇನ್ ಟ್ಯಾಕ್ಸ್ ಅಂತ ತಗೋದ್ಬೇಡ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ ಏನಾದ್ರು ಇದ್ರೆ ಅದ್ರೊಳಗೆ ಹೇಳಿ ಅಂತ ಅಷ್ಟೇ.
We'll have it next week. It's a 2012 matter. Have it next week. Mr. Nayak will not be able to come today.
Earlier, Babu Matthew, relationship knows Babu Matthew. He fought this case after Supreme Court. He was my ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ನನಗಿಂತ ಮೊದಲು ಅವರು ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ನರಸಿಂಹನ ಸೀನಿಯರ್ ನರಸಿಂಹ.
We'll have it next week.
2:30 ಯಾವ ತರ
we have the respondent short for release on 21st at 2:30 p.m.
August.
We have 10 days time to sort it out and address that.
Serial number 32 to 34 adjourned, 35.
35.
Ashwini Rajgopal.
Appearing for the respondent, Your Lordship.
Yes.
But all the petitioner wants to start with the argument, they can do it. And we will submit out the reply on the next date of hearing.
Senior has to come?
Yeah, for reply, senior has to come. Your Lordship.
Then we will adjourn it to another day. 35.
Okay.
None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, the petition would be liable to be dismissed for non-prosecution. We list on
20th, Your Lordship.
After 23rd.
Much obliged.
Senior should not come to court till 20th.
Yes, it will be communicated.
36.
Much obliged.
26 Ragupati illa. Dhananjaya and R. Krishna Narayan Swami. Passover 36.
37 to 39 adjourned, 40. K.V. Narayan Swami.
40. Mr. B.C. Prabhakar. Subramania.
ಫೋನ್ ಮಾಡಿದಾಗಲೇ ಏನೋ ಫೋನ್
ಇದ್ರು ಆಗ್ಲೇ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ಇದ್ರು ಇಲ್ಲಿ.
ನಾನು ಫೋನ್ ಮಾಡಿದ್ರೆ ರಿಸೀವ್ ಮಾಡಲಿಲ್ಲ ಏನಂತ.
ನೀವು ರೆಡಿನಾ?
ನಾನು ರೆಡಿ ಸ್ವಾಮಿ.
ಸರ್ ಆಗ್ಲೇ ಬಂದಿದ್ರು.
ಆಲ್ಮೋಸ್ಟ್ ನಾನು ಅದ್ರೊಳಗೆ ಮಾತಾಡ್ತೀನಿ.
41, 42 adjourned, 43. Yes, Santosh Narayan and connected matter.
The respondent has been placed ex parte in the matter. Paper publication of the one day.
All of them are expired.
All of them are placed ex parte. Even before the court, they did not appear for cross-examination. All the 4 cases is a common award which has been passed. The allegation is that the petitioner refused employment to the respondents with effect from 12/8/2009. They instituted a petition before the labor officer. On the first hearing, which was scheduled, the respondent submitted a reply at annexure B, page 16 may kindly be taken up. ಈಗಲೂ ಸಹ ಅರ್ಜಿದಾರರು ಬರಲೇ ಇಲ್ಲ.
ಆಲ್ ನೋಟಿಸ್ ಕೊಟ್ಟೇನೂ ಬಂದಿಲ್ಲ.
ಎಷ್ಟು ಸಲ ಆಫರ್ ಒಂದು half a dozen times we have offered employment. ಅಷ್ಟೇ ಇರೋ ಕೇಸ್ ಇರೋದು. Before the court, order is also passed on the memo saying that if they are not interested, we can't do anything. That also I wish. They are gainfully employed in other establishments.
Employer is before this court seeking for the following reliefs. By way of the impugned order passed in reference number 16, 17, 19, and 21 of 2010, the petitioner was directed to reinstate the workman into service with continuity of service and other constitutional benefits. Learned counsel for the petitioner submits that post the said order, the petitioner has returned to the respondent workman in the other.
No, they didn't come and report to work.
All notice have you issued?
Yes, call notice I have issued.
What is that for?
Annexure B, page 16.
All notice have been issued on
29th October 2009.
20th November 2009.
29th October. Annexure B, page 16.
Annexure B.
But again at annexure F, page 23 before the court.
29/10/2009. Yes. 2011/2009.
5 to 11 at annexure F, page 23.
5/2/2011. The respondent workman has not reported to work. Notice having been served on the respondents, the said service has been held sufficient and none has entered appearance for the respondent and there is no contest to the matter. The impugned order of the tribunal being for reinstatement, and despite orders having been issued, despite call notices having been issued to the respondent to report to work from a respondent not having reported, the respondent not having contested, and the considered opinion that the respondent themselves are not, respondent workmen themselves are not interested in reinstatement. Hence, there will be no purpose served by the order, impugned order, dated 4th July 2013, passed by 2nd Additional Labour Court, Bangalore, being enforced. Hence, I pass the following order.
The back wages for your, there shall not be entitled for back wages of the employer offering employment.
Petition is allowed. The certiorari is issued. The award dated 4/7/2013, passed by 2nd Additional Labour Court in reference number. Are hereby.
44.
44. Mr. Shastri. Harish Kumar.
45. Serial number 45. Nilkatra. 46 urgent.
ಬಹಳ ವರ್ಷಗಳಾಗೋಯ್ತು ಬರ್ತಾ ಇಲ್ಲ ಯಾರೋ ಇಲ್ಲ ಗೊತ್ತಾಗ್ತದೆ ಈ ಪಾರ್ಟೀಸ್
ಏನಂತ ನೋಟ್ ಮಾಡೋದು?
ಲೇಬರ್ ಪ್ರಾಕ್ಟೀಸ್ ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಬಹಳ ವರ್ಷ ಹಿಂದೆ
ಬಹಳ ವರ್ಷದಿಂದ
ಈಗ ಕಾಣ್ತಾ ಇಲ್ಲ ಸರ್, 8 ವರ್ಷದಿಂದ ಕಾಣ್ತಾ ಇಲ್ಲ. ಲೇಬರ್ ಕೋರ್ಟ್ಗೂ ಬರ್ತಾ ಇಲ್ಲ. ನಾಟ್ ಕಮಿಂಗ್. ಬಟ್ ಇದಾರ ಇಲ್ವಾ ಅಂತ ಗೊತ್ತಿಲ್ಲ ಅದನ್ನ.
So we take it that you have stopped practicing?
ತಗೋಬೋದು ಸರ್.
You don't want to say anything more than that.
ಅಷ್ಟೇ ಅಷ್ಟೇ.
Without it being stated.
ಹೆಸರಿನ ನೋಡಿದ್ರೆ ನನ್ಗೆ ಇಂಡಸ್ಟ್ರಿ ಯಾವ್ದು ನೋಡಿದ್ರೆ ಎಲ್ಲ ಯಾವಾಗ ಪಾರ್ಟ್ ಆಗ್ಬೇಕು. ಇದು ನೋಟಿಸ್ ಹೋದ್ರು ಏನು ಪ್ರಶ್ನೆ ಆಗಲಿ ಕೇರ್ ಆಫ್ ನೀಲ್ಕಂಠರಾವ್ ಅಂತ ಯೂನಿಯನ್ ಕೇರ್ ಆಫ್ ನೀಲ್ಕಂಠರಾವ್ ಅಂತ ಅದರಿಂದ ಏನು ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗಲ್ಲ.
If the party's name is mentioned somewhere else, then it can be. Somewhere in the petition, if the party's name is there. Something.
That probably will have to be given by Mr. Subramanya only. You can find out the. There is second floor Balaji residency are there, then care of. Both addresses are there. It is submitted that Shri Rao no longer practicing. Hence, legislative director issue notice to the petitioner at the Saraswatipuram address returnable by 28 March.
Urgent, 47.
And
48.
And the petitioner in this case, kindly pass over this matter at 2:30.
Also, 2:30. 2:30 ಅವರು ಇನ್ನೂ ಒಂದು ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತಾರೆ. ಎಲ್ಲ KSRTC ಮ್ಯಾಟರ್ಸ್ ಅದೇ. ಭಂಡಾರಿ ಇಲ್ವಾ? ಇಲ್ಲ ನೀವು?
ಇಲ್ಲ, ಅದರಲ್ಲಿ ನಾನಿಲ್ಲ. ಆಫ್ಟರ್ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್
ಎಲ್ಲ ಬಂದಿದ್ದಾರೆ ಇವತ್ತು. ಅವ್ರು ಸಿಗಲ್ಲ.
ಇಲ್ಲ, ನನಗೆ ಊರಿಗೆ ಹೋಗ್ಬೇಕು.
ಅವ್ರ ಜೊತೆನೆ ಹೋಗ್ತೀವಿ.
ಇಲ್ಲ, ಲುಕ್ ಆಫ್ಟರ್ ಸಮ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್.
ಮಧ್ಯಾಹ್ನ Mr. Bhandari is not there, Mr. Amin. You want to have him?
Next week.
At the request of the council for the petitioner, we list on first, 2nd March.
Yes.
Serial number 49. Punishment.
Workman also attended the superannuation.
Superannuation. Is it part of the one
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಿದ್ರೆ ಅವ್ರ ಹತ್ರ ಕೇಳ್ಬೇಕಲ್ಲ, ಆಫೀಸರ್ ಹತ್ರ. ಆಫೀಸರ್ ಹತ್ರ ಕೇಳ್ಬೇಕು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಿದ್ರೆ.
ಒಂದು ರೇಟ್ ಪಿಟಿಷನ್ ಇದೆ, ಅವ್ರದ್ದು ರೇಟ್ ಪಿಟಿಷನ್ ಇದೆ, ಎರಡು ವಜಾ ಮಾಡಿದ್ರೆ.
We have it on 16. Next week in the every day we are opening one court for you. To put on idunu mugsi.
Subsequent absentee is also there.
If there is a subsequent issue and if there any other this one, don't close. But some punishment undertake. Both the councils submit that if a short accommodation is done, endeavor to discuss settlement. We list on 16 at 2:30 PM under the caption reporting.
Serial number 50. Ashok Naik, connected by
Naik. Password.
5152 urgent. 53.
It's wanted to bring your lordship's notice in this petition, in the award passed by the Labour Court, the court has granted 3 lakhs. And if it is not deposited, interest at 18% interest is granted. The lordship will kindly take my writ petition, my lord. Connected petition, no. It has been connected, my lord. I had filed the writ petition first, my lord, 4310 of 2020.
There is no connected matter of yours listed today. Only one matter is there, 513, serial number 53.
I'm sorry.
You are for 4 to 7, and Srinivasan is for 8.
Yes, I'm sorry. 53.
I think so. You are also there for.
I am also there, my lord.
Minimum wages from plantation industry.
One appears to the petitioner today. If none were to appear for the petitioner on the next date of hearing, the petitioner will be liable to dismiss the non-prosecution. Released on 21st.
ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಂತ ಬೇಡ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಟೆನ್ಸ್ ಮಾಡಿದೆ. ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಬಂದು
ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಮತ್ತೆ ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತಾರೆ ಸುಮ್ಮನೆ, ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಲಾಸ್ಟ್ 3 ಸತಿ ಬಂದಿಲ್ಲ ಅವರು.
ಹೌದು.
We can't dismiss, we can't take up the matter on merits without the petitioner being there. Respondent illa andre we can take.
ನಾ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ಇನ್ನೊಂದ್ಸಲ.
Bandre will take it up on merits, otherwise. Because some of these matters, matters.
ಮಿನಿಮಮ್ ವೇಜಸ್ ಅಲ್ಲಿ ಕನಿಷ್ಠ ವೇತನ ಕೊಡದೇ ಇದ್ರೆ ಅದಕ್ಕೂ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ ಅಷ್ಟೇ. ಅದು ಲೇಬರ್ ಪ್ಲಾಂಟೇಶನ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡೋಂಥದ್ದು.
Plantation.
ಹೌದು.
It's on 21st, sorry, 21st.
Serial number 54 to 56.
Dismissal for non-prosecution. How was that?
Serial number 54 to 56, 57. Satish Chandra.
Satish Chandra.
58, Srinivasa K.
Appear for the respondent in this matter, my lords. Ready, my lords.
Also.
Yes, my lords.
Srinivasa K.
Also.
As for, very short point, afternoon, my lord.
After what do you have to do? Let the Srinivas come.
Please.
Comes regularly. Yes.
Yes, was not connected matter.
In 60.1, I'm appearing for the petitioner launch.
Rajiv Gandhi. Yes, Mr. Peshwa, you wanted to make some submission.
Yeah, I just want to make one submission. An employee by name Selvia Ashok Launch has been working for almost 17 years. He has been unfairly refused with employment, no communication, just that her name is removed from the biometric meter. And she's not getting salary for more than 4 or 5 months.
What is her name?
Selvia Ashok Desai.
Sylvia Ashok Desai.
Yes.
Sylvia Ashok Desai. Is this colleague. Oh. We have passed an unofficial order restraining Mr. Subrao to appear before us till the 20th. He is not well.
Today itself, my lord, with KG Raghavan sir, we were just saying that Subrao's senior sir, like from 30 till 5:30, he sits and my lord, he argues that stamina and that thing. Nobody has that.
He's not been well for last 15 years, but he is still appearing and arguing.
Look, last week when
hospital, is discharged from the hospital, Mr. Peshwa?
No, your lordship. Today there is a procedure which will happen on him, and in all probability on Sunday he may get discharged.
In fact, on 3rd, this matter was listed. The senior was there till the end of the day. That day.
He is there every day and he wants to argue. He had a throat problem last week. We told him not to argue. He did not listen. Now it is escalated. We want him to argue for a few more decades. ಅಂದ್ರೆ 75th year ಸೆಲೆಬ್ರೇಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಆಯ್ತು, ಅದು 16 ಆಯ್ತು. 75. We'll have to celebrate his 75 years of practice.
And one of the only exception which we were speaking just now, was dedicated his life for the labor. Nobody else, MC Narasimhan sir and Subrao sir, only two, totally dedicated.
There are things to be emulated and learned from them. Yes, Sylvia Ashok Desai.
Yes, your lordship.
She has been denied employment in terms of the biometric has been deleted.
Then he'll take instructions. I'll just check.
She has made many representations. They are not responding to any of the representation.
In the manpower agency, my lord, if I'm not mistaken, I think they must be working through the manpower agency at respondent number 2. In fact, if your lordship recalls, my lord, when the amounts were not paid, In fact, my lord, the matters that come up before your lordship, my lord, though there was an order by the learned single judge, we undertook that we will ask them to make the payment. They made the payment.
Yes.
Then, my lord, when it came up before the other learned single judge, they said if in case some amount is not paid, you can file any application for clarification. But we had made the payments, and the manpower agency said they have also made the payments to all of them. But with regard to this, my lord, we are not aware as to.
Just find out. He is making the submission.
Yes.
Find out and have.
Yes, let them just find out, your lordship. And all our representations have been sent only to the university, and they also acknowledge the representations, but they are not responded to her.
And if there is no issue, any disciplinary issue or any of those things, why don't you what do you say to the fingerprint of biometrics will have to be restored.
Yes.
That's all.
17 years she has been working.
70?
17 years she has been working for the university.
It's a very genuine and a proper concern which we'll address it. I'll also, if they're through the manpower agency or whatever, we'll tell, and we will ensure, my lord, that.
Just find out and see.
Yes.
If there's no disciplinary issue, then
Please, we'll do that.
Biometric.
Yes.
Muralidhar Peshwa, the head counsel for the petitioner in WP 13798 of 2022, submits that one of the workmen, namely Sylvia Ashok Desai, has been denied employment in as much as her biometrics have been revoked. The counsel for the respondent seeks for the senior counsel appearing for the respondent number 2 seeks for and is granted 10 days time to verify and make a submission. We list on 23rd February, 23rd.
Much obliged, your lordship.
That is okay?
My lord, like a fourth. My lord, 24th, 23rd, none for 24th, only one.
24th.
Please, only one day.
Okay.
Serial number 61, adjourned 62. A. Ramohan.
Mr. Nayak is not there.
Not come today.
Nayak is supposed to be there at 2:30 over there, I think.
He is in meetings with all the drivers. Meeting nadita idya. 500 jana jote. 500 drivers jote meeting nadita idya.
Mostly pendency.
Reinstatement ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ.
ಈಗ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಎಲ್ಲರೂ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವತ್ತು ಏನ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಪರಾಲ್ ಕ್ಲೋಸೇ ಮಾಡ್ಬಿಡ್ಬೋದಾಗಿ ನಾವು ಸಜೆಸ್ಟ್ ಮಾಡ್ದಂಗೆ ಕಂಟಿನ್ಯೂಟಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಅದರಿಂದ ಅವ್ರಿಗೇನು ಲಾಸು ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಏನೋ ಒಂದು ಈಗ
ಒಂದೇ ಸಿಟ್ಟಿಂಗ್ ಅಲ್ಲಿ ಆಗಲ್ಲ. ಇಟ್ ಇಸ್
ಅಂದ್ರೆ ಈಗ
ಆಗ್ತಾ ಇದೆ. ಇವಾಗ Mr. Nayak is not going to be coming today.
ಇಲ್ಲ
62 on behalf of the council for respond number 428. A short accommodation is sought for request on 6th March. Interim order earlier granted is extended.
Serial number 63.
Petition 830.
63. Yes.
For the responding,
Speak in the mic, we can't hear. It's like you haven't had breakfast for you.
appearing for the responding petition 8630/2020.
Yes.
Praise time for hearing. My senior is out of station. Maybe listed on Monday. Lord.
My only thing was, my lord, I have also filed a cross petition.
Yes.
Your lordship will just see the page number 33, my lord.
Yeah.
Page 33 in the cross petition. I have not been served with a copy of that petition, my lord. that there was an office objection also raised that's not complied with till now in their petition. In my petition, my lord, is the award. Your lordship will see 3 lakhs amount is.
You were supposed to deposit by 3/6/2020.
Yes, that is all.
The amounts, the direction of the court. We'll pass over the matter, seek instructions telephonically from your senior, and also serve a copy of the petition. So there's a direction to deposit the amount. Get instructions from him as to when you'll deposit. We'll have it in the afternoon. You understood?
Yes, ma'am.
What have you to ask your senior?
When can we deposit the?
Not when can we. There's an order of 12/4/2022. Make a note of it. 12/4/2022, there's an order directing you to deposit by 3/6/2022. Which you haven't done as it. So when will you be depositing? Check with your senior and make a copy of the petition and furnish a copy. That you can do, photocopy and pass over.
Kaveri Timaya.
And so many other.
I'm hating.
Just to get instructions. Srinivasan, we'll explain it. Don't get worried. Yes, madam. Yes.
I appear for the employer, your lordship, and the respondent had filed an application under section 33C2 claiming short payments of salary and non-payments of salary for the period 2000 to 2012. If I could take your lordship through the brief facts of the case, and I've also produced the documents as annexures, I'd be placing reliance on them. The respondent claims that he was appointed as an office assistant cum steno in the year 2000 for a monthly salary of rupees 3,000.
He was appointed in the year 2000.
Please, if your lordship would kindly look into page 49 of my petition. That is the memo stating his appointment. It says, with reference to the above, we are pleased to appoint Sri Shambhu Gowda, an office assistant cum steno, on a monthly salary of 3,000, and he will be in charge of office administration with respect to correspondence, maintenance of files, collection of fees, and he will also carry out the duties with responsibilities and to work for the development of the students and institution. Now, this was in the year 2000. In the year 2011, there was a reshuffle in the management body, and a new committee was formed with new office bearers. He has further gone on to say, and these are his documents that he has produced before the Labour Court. In the year 2006, he has produced another document which shows his designation as the office manager, which I have produced as at page number 54. It says, on behalf of the above institute, we hereby authorize Mr. Shambhu Gowda, office manager, to contact offices of the so-and-so, and it designates the works to be carried out by him. If your lordship would now please look at page number 58. And this is the document under which he claims that there have been short payments and non-payments of salary. This is a document signed by the erstwhile management in the year 2007, and we have strongly disputed it. He says he is designated as office manager. His salary is fixed at rupees 5,000 per month from effect from 2007. This is at page number 58. And he says his salary is now fixed at rupees 5,000 per month, and he is entitled for an additional increment of rupees 1,000 per annum commencing from January. Now, if your lordship would kindly look into page number 56, he goes on to produce another memo.
Rupees increment per annum.
Per annum, yes. He claims there is a salary hike from
2009, it will become 7,000.
Yes. He also claims that there is a salary hike from 3,000 to 5,000. His initial salary was rupees 3,000, and under this document, it reflects as rupees 5,000.
So is it your contention that from 2000 to 2007, There's no increase in the salary.
No, your lordship, no, your lordship, my grounds are, if your lordship would look into the award of the labor court, there was an issue raised whether he proves that he's the administrative officer, and that has been answered in the affirmative. And despite being answered in the affirmative, his other contentions have been considered. So it's my submission that when there is a finding to the effect that he is an administrative officer, then he should not be treated as a workman and his claim should not have been considered. And my other ground that I have raised is with respect to reference. I have judgments that I will be referring to, that in an application under section 33C2, the labor court acts as an executing court and it can only execute a pre-existing claim or a benefit or an award. In this particular case, it's not the situation.
There's a dispute about this.
If I may continue, if your lordship would kindly look into page number 56, this is another document that we have disputed, again, which he claims has been signed by an officer of the erstwhile management. It is under this document that he claims that he is promoted as the administrative officer. At page number 56, Sri Shambhu Gowda, office manager of this institution, is promoted as administrative officer with immediate effect. The duties and responsibilities for the post will be issued separately. He should report for duty forthwith. Now, your lordship, his entire claim of non-payment of salary from 2000 to 2012, the only document that he has relied on is a consolidated statement that has been prepared by himself and which he has signed it. I have produced that document at page number 62, your lordship. In fact, this document was marked as Exhibit A15 before the Labour Court. And if your lordship would go through the award of the Labour Court, the court has referred to solely this document, and it is on the basis of this document, which is prepared by the applicant himself and which is signed by the applicant himself, that the court has come to a conclusion that there has been a short payment and non-payment of salaries.
Where is this memo dated 18/6/2000? Note 1, Note 2, Note 3. Have those documents?
It's at page 49, your lordship. That is his letter of appointment.
That is the letter of appointment. There is a note from 22/6/2000 to May 2007. Salary calculated as per memo dated 18/6/2000.
That's the memo.
Calculation is in 18/6. There's only a table. So where's that calculation of 18/6?
That is the one that I produced at page 49.
That cannot be a.
But that is the one that he has referred to, your lordship. This is his document.
9 is the appointment.
But that is the one. That is the memo dated 18/6/2000.
That cannot be a memo, madam. That's a document which is marked as Exhibit A1. There's a document marked. There's a memo which is filed on 18/6/2000. As per memo dated 18.
That is the document that I produced, your lordship.
There is no calculation.
No, there is no calculation.
No
So the-
separate calculation. From December, this is the actual attorney. As per memo once. And 1/6/2000 is also being like that. That is A4. Yes.
Now, prior to filing this application before the Labour Court, he had filed a petition under section 10 before the Labour Officer Shimoga. If your lordship would please look into page number 84, annexure M. Now, the claims made by him in this petition are quite different from his claims made in the application filed before the Labour Court. I will only read out the relevant portions, your lordship. This is the petition before the Labour Officer. He says that he was the petitioner working as an administrative officer now on leave, para 2. Para 3, he says the management of the respondent society has promoted the petitioner to the position of administrative officer from 2008 by the then secretary. But salary structure has not been fixed. However, an honorarium was paid by the respondent by way of salary. It is also a fact that the administration of the society was entrusted entire office management of these 3 institutions with the petitioner. Thereafter, he goes on to say that without informing him, he has been asked to leave the the employment and impromptu farewell function was organized for him. And if your lordship would now look into page number 87, page 87, the last line of the first paragraph, here he says that the respondents have not paid the salary for the months of October and November 2012. There is absolutely no mention here of payment, no payment of salary or short payment of salary from the year 2000 to 2012. He says that the salary has not been paid for the months of October and November 2012. Thereafter, in para 12, he lists out the documents on which he has placed reliance. In this list, there is no mention of the 2007 document, your lordship, and this is the memo under which he had claimed that there was a salary increment to rupees 5,000 and that he would be entitled to 1,000 per month, per year. And his prayer is to reinstate the petitioner to his original position as administrative officer with all back wages. Now, before the labor officer, the petitioner paid him the 2 months salary of October and November 2012. And there was an endorsement issued. That's all that has been done. An endorsement has been issued saying that let the matter be referred to labor court for considering the short payments. That's all that has been done. And if your lordship would now look into the award passed by the labor court, there is absolutely no mention of this endorsement.
Where is the endorsement?
The endorsement is at page number 80, your lordship.
80.
80, yes. I'm sorry, page 102. It merely says that there was no unanimous negotiation between the parties and hence this endorsement.
The conciliation is paid. He has been asked to approach the labor court. The reference pay. Yes.
Now, during the pendency of the matter before the labor court, he has again filed a petition before the labor officer Bhadravati. And in that there was and in the course of that proceedings, we have paid him the salary for the years 2012 to 2014. And that is produced at page number
2012 to 14.
2012 to 14.
That is why the matter was pending before that.
Please. That's at page 103, your lordship. Here too, there is an order passed that the petitioner and management, if willing, may solve the remaining issues amicably and withdraw the case before the labor court, failing which they are at liberty to continue the case. Now, your lordship, we have denied his documents dated 2007 and 2008, under which he claims that the erstwhile management had issued this memo enhancing his salary to 5,000 or even giving him an increment of 1,000 per year. We have disputed this in our objections before the labor court. Now, if your lordship would please look into the order passed by the labor court, there were two issues that were raised at page number 21.
What is the suit in OS 220? The suit in OS 220.
Your lordship, there was another issue. Now, we were not able to produce the salary registers showing the payment of salary to him. In fact, it was our contention that we were not in possession of any of these documents. In fact, it was he who was looking after the salary registers as well. He had filed a suit asking us to produce these documents. It got dismissed on the preliminary ground of lack of jurisdiction by the civil court. Because this is one of the grounds that has been raised in the labor court's award, saying that the duty was cast on the management to produce these salary registers, whereas it has throughout been our contention that we are not in possession of these documents at all. Now, if your lordship would please look into page number 21, there are two issues that have been raised before the labor court.
So if you don't have the salary register, who has?
We are saying that it must be in his possession because he was the one who was handling these documents.
Can you get away with that kind of submission when you are the MC and you don't have the register?
But also because there was a reshuffle in the management, it was the erstwhile management that was previously in charge.
It is still the society.
Please. But your lordship, my contentions are restricted to these 2 points of the Labour Court having passed an order stating that he is an administrative officer, and secondly that
The register you don't have is not something that can be accepted.
But your lordship, he was in possession. That's been our contention throughout in those civil suits filed by him as well as in this.
Have you initiated any proceedings against him?
No, we have.
Don't look at statement. Statement in defense. That cannot be. Yes.
That is the reason not addressing arguments on those lines, your lordship.
You owe me 1 lakh of rupees. No. I don't owe you 1 lakh of rupees. You owe me 5 lakh of rupees. Yes. What have you done after that?
Your lordship, the 2 issues raised are whether the applicant proves that he's been promoted as an administrative officer as claimed in the application. My submission is that when this issue has been proved in the affirmative,
It is an administrative officer.
his application should have been dismissed, your lordship. And I've also produced a memo with citations. This is with regard to whether the Labour Court had the power to even, or the jurisdiction to even consider this application, in light of there having been no reference. The petition that he had filed under Section 10 had completely different averments from the application that he has filed before the Labour Court. So, your lordship would kindly look into my memo of citations that I had filed. File it on 3rd of October.
Copy has been served.
Page number 1, the first judgment, that is Bombay Chemical Industries versus Deputy Labour Commissioner. I will read out the relevant paragraphs. The respondent number 2 herein, para 2. The respondent number 2 herein moved an application before the Labour Court under Section 33C2 of the Industrial Disputes Act, in so and so demanding the difference of wages from 2006 to 12. The said application was contested by the appellant herein denying any relationship of employee-employer. It was the categorical stand of the appellant that R2 herein was never engaged by it. Before the Labour Court, R2 herein relied upon the documents exhibit so and so in support of his case that he had worked in the establishment as a salesman, and that by order dated so and so the presiding officer Labour Court allowed the said application and directed the appellant herein to pay the difference of wages from 2006 to 2012. Paragraph 3.1. It is submitted by so and so appearing on behalf of the appellant that the High Court ought to have appreciated that when there is a serious issue raised with respect to the employer-employee relationship between the appellant and R2, and that it was seriously disputed that R2 was at any point of time in employment as a salesman, the Labour Court ought not to have entertained or allowed the application under Section 33C2, as the same could have been decided in reference under Section 10 of the Industrial Disputes Act. It is therefore submitted that the order passed by the Labour Court is completely without jurisdiction. Therefore, the High Court ought to have set aside the same, and they placed reliance on Municipal Corporation of.
Let's go to the finding.
Para 7, page 3. Applying the law laid down by this court in the aforesaid decisions to the facts of the case on hand, when there is no prior adjudication on the issue whether R2 herein was in employment as a salesman as claimed by R2 herein, and there was a serious dispute raised that R2 was never in employment as a salesman, and the documents relied by R2 were seriously disputed by the appellant, and it was the case on behalf of the appellant that those documents are forged and false. Thereafter, the Labour Court ought not to have proceeded further with the application under Section 33C2 of the Industrial Disputes Act. The Labour Court ought to have.
There is a dispute about the employment itself.
Please do.
Yeah, there is no dispute about the employment.
But your lordship, he claims to have even been promoted to the post of an administrative officer, which we have disputed.
Those are documents which are your own.
We are stating that those documents are forged. In fact, there is a
action have you taken on forgery?
Not taken any action.
Anybody will come and say it is fraud, forgery.
There's one document, that is minutes of a meeting. This is not being produced before the labor court, your lordship.
That one submission is made in any matter. To be accepted, every matter will have to be dismissed.
No, because the signatures on these two documents that we have disputed.
But what action have you? Have you filed a criminal complaint? Have you filed a suit? Have you done anything? Or just sit in the office and say this is a forgery and keep quiet?
But my contention, your lordship, is that the labor court did not have the jurisdiction at all to.
That is one part that you are yet to address. That is one part of it. The other part of it is that is as him being the administrative officer, not being workman under 2 years. That is one part of it. You are relying on this to say that there is a dispute as regards his employment. There is no dispute as regards his employment.
But this also states that the documents also that the respondent had relied on were disputed. The applicant.
Merely saying so is not a dispute.
But your lordship, my contention is that this should have been considered not before the labor court.
Yes, next.
I produced another judgment. If your lordship would please look into page 6 of my memo of citations. Para 9. Paragraph 9, page 6. Whenever a workman is entitled to receive from his employer any money or any benefit which is capable of being computed in terms of money, and which he is entitled to receive from his employer and is denied of such benefit, can approach the labor court under section 33C2 of the Act. The benefit sought to be enforced under section 33C2 of the Act is necessarily a pre-existing benefit or one flowing from a pre-existing right. The difference between a pre-existing right or benefit on one hand and the right of benefit which is considered just and fair on the other hand is vital. The former falls within jurisdiction of labor court, exercising powers under section 33C2, while the latter does not. It cannot be spelled out from the award in the present case that such a right or benefit has accrued to the workman, as the specific question of the relief granted is confined only to the reinstatement.
This is as regards back wages being implied in reinstatement. You are not.
Please, but your lordship, if I could place reliance on the citations that have been produced by the respondent as well.
You show us those and let us see that. This judgment is whether back wages is implicit in reinstatement. It is not so. No. The labor court has to be slightly clear and categorical.
Similarly, in my case too, he is not asking for short payments or non-payments of salary on the basis of a statutory claim. In fact, most of the judgments that have been referred to by the respondent are judgments where the court has held that an application under 33C2 will be maintainable when there is a pre-existing award or when there is a statutory claim.
Yes, and that, but what his submission would probably be is that look at this document. It just says 5,000 rupees plus 1,000 rupees. But there is a pre-existing agreement. It's only a calculation which has to be made. There is no dispute resolution which has to happen. Base mathematical calculation to be made is not a dispute. Is what the submission.
My response to that would be that it's not a pre-existing right.
Yeah. So you will have to show us something on that. This won't help you. Implied whether the back wages is implied in the. So that's not a question here.
But your lordship, in this instant case as well, it's not a pre-existing right that he gets. He's solely relying on these memos.
Yes. Next.
And my last decision is judgment is if your lordship would please look into page number 9, paragraph 4. In case of a reference under section 10 of the Industrial Disputes Act, the labor court is not empowered to travel beyond the terms of reference. Either it must be shown that it is a specific term of reference on which the particular relief is claimed before the court, or that consideration of such matter is incidental to the terms of reference and the reliefs claimed thereupon. Unless that is shown, the industrial court cannot go into the question. In this instant case, his claims before the labor officer were completely different.
Was there reference made in this one? That was your first contention that there's no reference. So when a reference is made by the appropriate government, questions are referred to that particular tribunal or the court. They cannot go beyond the reference. There's no. All these decisions are completely right. They've been followed by so many other decisions, but are they applicable to your case?
It is my contention that he does not have a pre-existing right, or there is no award that he can rely upon for the labor court or had jurisdiction under section 33C2.
Yes. Anything else?
God. He was taken to the employment. He was here.
Only one question you have to answer.
Yes.
To cut short this.
Administrative officer. Yes, ma'am. The
13
Lordship
may be right, but
yes,
you claim it.
yes, ma'am. Page number 46. Your Lordship may see the contention taken by them.
46.
Because once there is pleadings, there is nothing more required. Evidence is required.
Yes.
Page 46, your Lordship may see. It is. It starts from page 45, which is the objections filed by the management, the respondent therein. That is, the management has filed this. The present management has filed this. Para 5, my lord. Next page 46. May I read, my lord?
Yes.
Without prejudice to the above arguments, this respondent humbly begs to submit the following true facts, set of facts before this honorable court. The applicant has falsely claimed the salary and other benefits payable to the administrative officer. In fact, the applicant, it is their contention. In fact, the applicant has never worked in the capacity of administrative officer in the institution, and moreover, the applicant is not qualified person to be appointed as administrative officer of the institution. Hence, at no stretch of imagination, the applicant is entitled to the benefit. My lord, straight away they themselves say, I am only a clerk. I am not even qualified to be an administrative officer. My case, my lord, is also
works against you also, Mr.
Yes,
your claim, you are going to accept their submission, their pleading that you are not qualified. Then you cannot claim on the basis of the 2007.
Yes, my lord. What I will, my lord, it is that contention. My lord, after my retirement from another institution, the present management, the earlier management had taken me into service. After my 60 years, I joined this company and I was working. They paid me 3,000 rupees per month. Then thereafter, they said 3,000 is after 7 years. They said, we will pay you 5,000 instead of 3,000, 5,000. And from the next year, from there onwards, 1,000 rupees will be increased. Thereafter, in 2000, this happened in 2007. 2011, there was the same members, there was a reshuffle. Actually, initially, it was the father, wife was the person who established it. The husband and son, they were the three people. They are the one who have signed those memos. They are a same family who started this institution. They are the one who employed me. They are the one who increased my salary. There's no dispute with regard to that. Only they are claiming he is not the secretary, he is not the president. It's a family run thing initially, my lord. Then thereafter, whoever the members were there, they took over the institution because she passed away, he also passed away. Only the son was there, he was not interested. He just gave it to the new management and he retired old place. Now, after new management, they didn't want to continue me in employment. It's up to them. I am also always
working. Asking for reinstatement, you're only asking for the.
Yes. So with regard to those benefits,
yes.
Initially, my lord, he approached the labor officer thinking that there itself he could get it resolved. And then with regard to the 2 months which was not paid salary, he claimed that 2 months salary which was not paid at all, he claimed before the labor officer. And with regard to his employment also, he said suddenly they have not even giving me notice, they are just asking me to go. He had claimed it. Finally, he did not press for it. He is retired from service. Now the 2 months salary they paid at that.
The base of this memo.
Yes, my lord.
That you have filed.
Yes, ma'am.
You are saying 18,900 was to be paid. But what was paid was only 6,000 rupees and there's a balance.
Yes, my lord. The court, my lord, have appreciated these facts. They have rejected most of my claims and only partly allowed my claim. In fact, I should have filed a cross petition, but by now he is 76 years old, and he says I'm no more interested in litigation. But most of my claims have been disallowed. Court, your lordship may see, it has rejected my claim. They said even for those 2 months, the difference amount is not paid by me. Only the difference amount is claimed by me based on a pre-existing right, which is by way of a contract between me and when an appointment.
You'll have to show at least that what has been paid to you.
My lord, what has been paid to me, I have, my lord, they have not even given I place a statement of calculation. How under 33C2, how the code goes, my lord, it's like an executing code. Now, I place a record. If the other side does not place a record saying that it is not 5,000, we were paying only 4,000. If they take a claim, fine. All that they say is this court does not have jurisdiction. We don't have records. You do what you want. Now, having after
Court did what it wanted.
Yes, my lord, what can the court do? The court has to decide on the material placed before it. If there is a lord under 33C2, the calculations are so very difficult. Sometimes we refuse to take some matter. Even when there is an award and all that, how would we be able to calculate over 5 years or 10 years? What are the increments which are taking place? How much percentage of DA? What was the cost of price index? All that we expect a management who has got a personal department to come up with some kind of a calculation. If mine is correct, if theirs is wrong, then definitely that could be corrected. They have not placed a statement of calculation. This statement is signed by me because it's a statement of calculation. It is not a document which I have fraudulently prepared and signed and brought it to the court. It's a statement of calculation, that is all. So that has to be refuted by another statement of calculation. The court has got only those materials. That is what the court has said. It's a finding of fact. Court has said you have not disputed that. My lord, the fact that he is an administrative officer is actually, my lord, if your lordship sees, it is only to see whether he was entitled to a higher pay. That administrative officer actually does not matter at all. Now the question is whether his salary was fine, because we are not going to. The question was only the salary difference. That could be established by even without giving a finding that he is an administrative officer or not. The salary only to justify. Issues were framed like that, only to justify how the salary was increased and how over a period of time he was given a higher post only for that purpose. That is not the material in this under 33C2. It is only the difference in salary. Under 33C2, your lordship is aware, it is only relating to, my lord, I have placed under 33C2, it is where I have a right, where the money is computable in terms of money. That is all that is required. I have an inherent right. It can be computed in terms of money. Under 33C2, I can proceed. That's what the courts have said. It is an easy, efficacious method for a worker not to get into so many difficulties when he is due some money under any statute or under any agreement. You can enforce it. But you cannot go to determine the right. If the right has to be determined, it is only under 10(1)(c) or under the other provisions of law. If once it is by a contract, by a letter, if I'm even by a custom, if I'm able to establish, I've been paid customary bonus every Diwali on a particular date, even without a document, if I'm able to establish, that is an inherent right which the courts have recognized and said, once you have a right, you can claim it under 33C2. 33C2, there is a difference. 33C1 and 33C2, slight differences there. That is all there is, which I have placed the judgments before the court. Now, my inherent right.
When did you file your judgment?
I served a copy on the other side, and I have filed it on 8/2/23, my lord.
Not here.
8th February.
Yeah. It's not here, Mr. Nas.
Lord, I finished.
Have a set for you.
Your lordship may. that this copy,
This is your marks. Sir. Both of you have marks each other.
Yes, madam. That I'll, yeah. I'll just point out some lines which are marked already, so that later on I'll provide a better copy.
This is Madam's copy, so
Yes,
it would not have your marking.
Yes, madam.
Which para?
My lord, initially, my lord, your lordship may, I'll just first take on the preliminary issue, whether a workman, my lord, or serial wise, I'll take your lordship. My lord, the first decision, the central bank, this is relating to the question was, my lord, at page number 2, my lord, para 5, clause 2, where any workman is entitled to receive from the employer any benefit which is capable of being computed in terms of money, the amount at which such benefit should be computed may subject to any rules that may be made under the act be determined by such labor code as may be specified in this behalf, is what the act says. My lord, in page 3, my lord, page 9, para 9, middle portion, my lord. The argument is, if there is a dispute about the workman's right to claim the benefit, that has to be adjudicated upon, not under subsection 2, but by other appropriate proceedings permissible under the Act. And since in the present appeals, the appellant disputed the respondent's right to claim the special allowance, the labor court had no jurisdiction to deal with their claim. In other words, the contention is that the opening words of subsection 2 postulates the existence of an admitted right vesting in a workman and do not cover cases where the said right is disputed. My lord, the distinction between, my lord, that para, next page, my lord, page 11, para 11, my lord. Para 11, almost 10 lines from the bottom, my lord. Item number 1. In other words, the provisions of 22 roughly corresponds to section 33C2. It was initially 22, which was amended by 33C. There are, however, 2 points distinction. Section 22 has confined the benefits claimable by the workman under the award or decision or of an industrial tribunal, and the application to be made in that behalf had to be filled before the industrial tribunal which made the said award or decision. These 2 limitations have not been introduced under 33C2. That is to say, my lord, 23 was the initial provision. It was restricted to any settlement or award. That's all it said. But whereas 33C2, the courts have said, is much more wider. It takes into consideration a right which flows from any contract or law. Supposing it's under Payment of Wages Act, I have to be paid wages. I can go under 33C2 straight away ask for my wages. I don't need a prior adjudication. It may be disputed that my salary is wrong, calculations may be disputed, but still the court can go into it, is what the courts have said. So it is a wider provision is under 33C2, is what the courts have held. That is at
vis-a-vis 22.
Yes, ma'am. My lord, at page 5, my lord, the last 2 lines, ma'am. If a dispute is raised about the workman's right to receive the benefits in question, that cannot be determined by the labor code. The only point which the labor code can determine is one relation to the computation of the benefit terms of money. We are not impressed by the argument. In our opinion, on a fair and reasonable construction of subsection 2, it is clear that if a workman's right to receive the benefit is disputed, that may have to be determined by the labor code. Before proceeding to compute the benefits in terms of the money, the labor code inevitably has to deal with the question as to whether the workman has a right to receive the benefit. If the said right is disputed, nothing more needs to be done by the labor code
can proceed to compute the value of the benefits in terms of money. But if the said right is disputed, the labor code must deal with the question and decide whether the workman has the right to receive the benefits.
This is Manupatra, 1 or 2 words to message.
As alleged by. Yes.
Anything else in this decision?
Yes, my lord, and page number 7, the last 3 lines. If an employee is dismissed or demoted, it is a case that the dismissal or demotion is wrongful. It would not be open for him to make a claim for the recovery of his salary or wages under 33C2. His demotion or dismissal may give rise to an industrial dispute, which may be appropriately tried. But once it is shown that the employer has dismissed or demoted him, a claim that the dismissal or demotion is unlawful, and therefore the employee continues to be the workman of the employer and is entitled to the benefits due to him under a pre-existing contract, cannot be made under 33C1. If a settlement has been duly made, it can be claimed under 33C2, not under 33C1 is what the court said. My lord, in next decision, my lord, Ram Kawal case also, it is even in the head note, it is stated, my lord, even under the statute, the last line of the head note.
We'll come back.
Yes.
Grievance matter. Yes, madam. Okay. 66.
Instructions regarding the power.
Power line and marking.
Regarding the line, not the KPTC in the power, Karnataka power grid. That's the reason.
I will implement them, my lord. Your lordship may kindly permit me.
Who is the standing counsel?
Pardon?
Who is the standing counsel? Even our Gunu.
I will implement, my lord. Your lordship may kindly grant me an interim order.
You take it up when it is. We'll record yours.
Serial number 50.
50.
Can I have the passport?
This is the counsel for the petitioner released on 7th March.
Serial number 27. For the respondent.
Yes.
Counsel from Mysore is going to come and appear, requesting on 20th.
Oh, we need to support for the petitioner. SC Vijay Kumar will be appearing.
No, they have not yet come.
So Mr. Pyati is no more. Mr. MC Pyati is no more.
I have no.
So who will be appearing for the petition? First matter.
27.
Requesting on 20th.
We can't take it up until this is sorted out as to who is going to appear for the petitioner.
Yes.
So if Mr. SC Vijay Kumar will accept notice, then he will appear. As in the first matter, we'll have to issue notice to the parties.
Yes.
Let's see if Mr. Vijay Kumar.
List number 2, my lord, item number 10, final disposal matter. I don't know your lordship will have time today afternoon. So therefore, can it be listed on Monday, my lord, just about 10-15 minutes matter?
I don't know whether we'll have the time. If you want time, you ask us.
No, but I have seen about 6 or 7 afternoon matter, 2:30 listed matters and
some of them are already adjourned.
Oh, so then I can wait and take a chance.
You want to take a chance?
I'll take a chance.
But we don't.
I'll be very happy to do.
But we don't know whether it will reach.
I am aware of it.
Serial number 1.
My lord, sir. My lord, serial number.
Just one moment. Just one.
Serial number 1.
Yeah, the second list.
Lord, I am for the petitioner, please.
Yes, Mr. Kashyap.
Lord,
Yeah, just one moment.
still it just called me saying he wanted some time.
Just one moment.
please.
ಇವತ್ತು ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್
ನಿಮ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ.
2:30 ಯಾವಾಗ ಹಾಕಿದ್ರೆ ಅವರು ಇದ್ದಾರೆ.
Yes, Mr. Kashif.
My lord, I have no objections, my lord, except my lord, between 18 to 27, your lordship may not fix a date, my lord, because Mr. Savkar will be traveling on those days. Except that, my lord, I have no objections.
Mr. Subramania, we list on 2nd March at 2:30 p.m.
Please, grateful.
My lords, list number 2.
Yes.
Serial number 11, my lords, I need a short accommodation. I have to produce certain documents on record on the petitioner in this matter.
For the petitioner, we list on 13th March.
My lords?
13th March.
My lords, okay, fine. Thank you.
Lordship,
Go back up.
serial number 8, your lordship, second list.
Yes. 8.
Yeah.
Counsel for the petitioner is unwell. Relist on 3rd March.
Much obliged, your lordship.
Mr. Somshekhar.
In fact, I have informed Somshekhar, your lordship.
Yes, my lord. Yes, my lord.
3rd March.
Yes, ma'am.
Since there is uncertainty about sitting,
There is no uncertainty about sitting is there. It will reach just wait. You want adjournment? We'll adjourn.
No, my lord, I want it.
You have the interim order, you have to do.
Serial number 20.
Number 20. Yes.
He is held up with personal work, my lordship.
Yes.
He is held up with personal,
Who is elder?
my senior, my lordship.
Who is your senior?
Nanda Kishore.
Yes, we know. We are waiting for Mr. Prashant Chandra to come.
Yes.
Let him come.
Some 30 ಏನಾಗಿದೆ serial number?
Madam.
58 and 59 same. ಪಾಸವರು ಒಂದೇನ ಫಸ್ಟ್ ಪಾಸವರ ತಗೊಂತಾರೆ.
ಕಾಪಿ ಇಲ್ವಮ್ಮ ಅದು
ಅದಕ್ಕೆ ಚೆಕ್ ಮಾಡೋಣ. ನಾನು ಫ್ರಾನ್ಸ್ ಅಲ್ಲಿ
ಹಾ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 65 ನಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರಾ?
ಬರ್ತಾರೆ ಒಂದ್ ನಿಮಿಷ. ಹಲೋ
65 ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಮಾತಾಡಿ ಸರ್. ನಾರಾಯಣ ಸ್ವಾಮಿ, ನಾರಾಯಣ ಸ್ವಾಮಿ ಅಣ್ಣ ఏమైంది?
వాళ్ళు ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ನಮ್ ಸರಿ ಇದೆ.
ఏం తీసుకుంటాం ఏం తీసుకుంటారులే.
ఓకే, వచ్చినప్పుడే తీసుకోండి అమ్మా.
వచ్చినప్పుడే చెప్తాను. మీకు ఇన్కన్వీనియన్స్ అని చెప్పేసి టైం తీసుకుంటాను. ఇన్కన్వీనియన్స్ అని చెప్పేసి టైం తీసుకుంటాను. ఓకే,
రీచ్ కాలేదు కదా
తిరిగా రీచ్ కాలే.
సరే, ఓకే
ఓకేనా, థ్యాంక్ యూ.
ಏನು ಅದು ಫ್ಯಾನ್ ಎಲ್ಲಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಟ್ಟಿರೋಕೆ ಅಂತ ತೋರಿಸಿದ್ರೆ ಇಲ್ಲ 35 ಜೋಡಿಸಿದ್ವಿ ನಾವು. ಮೋಸ್ಟ್ಲಿ ನಂಗೆ ಗೊತ್ತಿದ್ದಂಗೆ ಅಲ್ಲೇ ಇರೋದು.
Both of them. Court officer. Court officer. Court officer.
Hello. ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಯಾರಿದ್ದೀರಾ?
ಮೇಡಮ್ ನಾ SCGP ಇದ್ದೀನಿ,
ಹಾ ಸರ್.
ಪ್ರಶಾಂತ್ ಮುಗ್ಲಿ ಅಂತ ಹೇಳಿ.
ಎಸ್ ಸರ್.
ಇಪ್ಪತ್ತು.
ಸರ್?
And respond.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 45 ಏನಾಗಿದೆ? ಸುಬ್ರಹ್ಮಣ್ಯ ಮಾತಾಡ್ತಾ ಇರೋದು. 45
ಸರ್ 28/3 ಡೇಟ್.
28/3 ನಾ?
ಹಾ ಸರ್. ಈ ಕಡೆನೂ ಇಟ್ಟಿದೆ ಅಲ್ಲ ಲಿಸ್ಟ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು 230 ಮ್ಯಾಟರ್ ಇವಾಗ ತಗೊಳ್ತೀರಾ?
ಹಾ ಹೌದು. ಫಸ್ಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ.
ಓಕೆ.
ಅದಾದ್ಮೇಲೆ ಒಂದ್ ಮ್ಯಾಟರ್ ಸಿಂಗಲ್ ಅಲ್ಲಿ ನಡೀತಾ ಇತ್ತು, ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಗೌತಮ್ ಲಾಕ್ ಮಾಡ್ಬಿಡು.
Matter pertains to Dharwad bench. Serial number 1. Pressure.
Mowgli?
Please, madam.
Yes.
My lordship, we have intimated to the government, my lordship.
The report ಬರ್ಬೇಕಲ್ಲಪ್ಪ.
ಅಲ್ಲ, court direct ಮಾಡಿದ್ರೆ we will send. We are waiting for government.
We have already passed an order.
Please. Alla specific.
Evaluation has to be done and
Basis on that, my lordship, we have communicated to the government, my lordship. 28.
We have to get the report from demands. Dharwad Institute of Mental Health and Neurosciences. Probation officer ಬೇಕು ಆಮೇಲೆ report of the ಬೇಕು.
ಈ ಜಯದೇವಿಗೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರೆ ಮೇಲೆ ಡೈರೆಕ್ಟ್ಲಿ we can.
ಏನು
we are waiting for the government order. ಅಂದ್ರೆ ಡೈರೆಕ್ಟ್ ಅಲ್ಲೇ ರೆಫರ್ ಮಾಡಿದ್ರೆ it shall be for examination and for medical examination of the victim. ನಿಮಾನ್ಸಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡ್ದಂಗೆ ಅಲ್ಲೇ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ. My humble request, my lordship, we have communicated to the government, my lordship, but our prison manual as per 539, my lordship, power of Director General of Prisons and Correctional Services.
ಏನಾದ್ರ ಪ್ರಕಾರ 539?
Court directs, my lordship, directing to the.
And then what do you want the direction to whom?
Director General of to the accused, my lord.
Accused is in custody.
Please, my lord. If court directs that he should be examined in the Jaidava Bangalore, my lordship, we have written communication to the government, my lord. We are waiting for orders from the government, my lord.
Mr. Mowgli, please take the order dated 27/1. Idya ನಿಮ್ಮ ಹತ್ರ order copy.
ಇದೆ.
Order ನೋಡ್ಬಿಟ್ಟು there is no Jaideva in this order.
I was under. Please. I'm sorry. Para number 5 in the event BIMS not having above facility, head of the Dharwad Institute of Mental and Neurosciences, Dharwad is directed to continue the suitable team for the purpose. Atara there is a direction. Please.
ಇನ್ನೇನ್ further direction ಏನ್ ಬೇಕು ಅಂತ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು. Let's you see the order dated 27/1.
Please, BIMS has indicated that they do not have a facility carry out a psychological evaluation of appellant. They have referred the matter to the Dharwad Institute of Mental Health and Neurosciences, wide letter so and so. However, the report of demands not put up on that.
So ಏನ್ ಡೈರೆಕ್ಷನ್ ಬೇಕು ಇದ್ರ ಬಗ್ಗೆ ಹೇಳಿ.
ರೆಫರ್ ಮಾಡಿದ್ರು ಸರ್ ಬಿಮ್ಸ್ ನವರು ಅದಕ್ಕೆ ಡಿಮ್ಯಾಂಡ್ಸ್ ತಗೋಬೇಕು ಕಿಮ್ಸಿಗೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಹಾರ್ಟಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅಂತ ಹೇಳಿ ಈಗ ಅವರು ಕಿಮ್ಸ್ ತಗೋಬೇಕು ಜಯದೇವ್ಗೆ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
There is a further reference to the Jaidev Hospital as the accused is suffering from some heart related problem.
That is a different.
He is referred to the Jaideva Hospital, my lord.
That's a different issue altogether, which the jail superintendent is entitled to and authorized to take action. He wants a psychological evaluation report because he has been convicted and he has been convicted to death, and there is RC pending.
Please.
Are you aware of the facts of this matter, Mr. Mowgli?
Just now the file is given, my lordship, and it was told that
They
the
can-
report is directed.
Is the case of where there are 5 murders which have been committed by him,
Please,
and he's been convicted to be hung until death.
please.
So there is a RC which is before us for confirmation of the death sentence.
Please.
So for that purposes, we have asked for his psychological evaluation
Evaluation. The report.
and the probation officer's report.
Please.
As also the report of this Superintendent of Central Jail, Belgavi, as to his conduct.
Please, but those reports are not.
How long does the report take? Because we ordered this in December and now we are in February.
Please, my lordship. Report
The report doesn't come, next time we'll ask the Superintendent of jail to be present here in person in Bangalore.
Dated 24/1/2023, my lordship.
ನಾವು ಇಲ್ಲಿ ಬಂಕರ್ ಸರ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
My lordship, there is a conduct and behavioral report from the state of government, my lordship.
Yes. Apart from that, please see our order dated 12/12/2022, where all the directions have been given as to what reports have to be placed.
On 24th, we have received the conduct and behavioral report, my lordship. I'll submit the same before the honorable court, my lordship.
These directions are in furtherance of the decision of the apex court in Manoj and others, the state of Madhya Pradesh.
Please.
So those are to be complied with by the state.
There are two documents, my lordship. Those were not produced before this honorable court, my lordship. One is 4/2/2023, my lordship.
Where is Mr. Bankar?
He's not keeping well, my lordship. Some health issue. He has undergone some operation, my lordship.
You can speak to him and get instructions properly. Please read our letter, our order dated 12/12. And 12/12/22 and 27/1/23 are two detailed orders.
Please. There are. Please.
Those are to be complied with.
Please. We have certain documents, my lordship. See to that those will be produced before this honorable court, my lordship.
Yes, and you should do it fast. This is taking too much time.
It will be concluded as soon as possible, my lordship. Because of ill health of my senior, my lordship, he could not before the court, my lordship. Please.
Please wish him best and speedy recovery.
I'm sorry, my lordship. Please.
Shri Prashant Mogli submits that the additional public prosecutor is unwell, and as such the reports could not be submitted. He seeks for 2 weeks' time.
May I submit, sir?
24th February at 2:30 p.m. Yes, Mr.
May I
Mate?
submit?
Yes, Mr. Mate.
My presence may be kindly be noted, my lord.
Okay. SL Matti. Presence is noted.
Obliged.
Please.
ಅದಾದ್ಮೇಲೆ number 64.
You have given us a fresh set, Mr. Srinivas.
Yes, ma'am.
Sir, file ಮಾಡಿದ್ದೀನಿ ತರಿಸಿದ್ದು.
ಆಗ್ಲೇ ಕೊಟ್ಟಿರ್ಬೇಡಿ ಮಾರ್ಕ್ ಮಾಡಿ. Just 1 minute.
Yes, please.
Second judgment.
Not at page 12, my lord.
Yes.
Ram Kabul.
Yes.
My lord, the last head note, last line. Or a statute under which the right is claimed. That is also available in the main portion, my lord.
You are reading which para?
Not that is from at page 13, my lord. The second column, my lord, the last para and the second column. At page number 606 of the internal.
33C2.
Yes, my lord.
Where any workman is entitled.
33C2, where the workman is entitled to receive from the employer any benefit which is capable of being computed in terms of money. The amount at which such benefit should be computed may subject to any rules that may be made under the act. That is the thing. Para 4, my lord.
Yes.
My lord, para 4, your lordship may, it's a difference between 33C2, they have excised, my lord. From the portion in the middle, when the order of termination has been set aside from there. Your lordship has got it. After 33C1, my lord, in the middle. Or I'll read it. When the order of termination has been set aside and the petitioner has directed to be reinstated with full back wages, a right has been accrued to the petitioner to get the back wages under the award, and the claim of the workman for the monetary benefits is capable of being computed, and therefore the claim of the petitioner for back wages, bonus and leave salary will fall within 33C2 of section 33C. No further adjudication is required regard to the claims made by the workman as already stated. The last 4 lines. The existing right should have vested either under a settlement of an award or under the chapter 5B or conferred under the provisions of any statute. So the right can flow from anything. Either from a statute it can flow, or from a agreement it can flow, or from an award. 33C2, you can proceed under 33C2. Whereas under 33C1, it is only in respect of an award or a settlement. Whereas 33C2 is wider in scope. So, where even under any statute, for example, under the Factories Act, if I'm able to get overtime wages, I can claim under 33C2. Under Payment of Wages Act, if I'm entitled to get monthly wages, that I can claim under 33C2. Anything is probably any other right under any statute.
There is a pre-existing right.
Yes, ma'am. And in fact, my own case, our own High Court, my lord, in the same thing where I had claimed overtime wages in respect of a worker, my lord, that the court had upheld, my lord, and said that at para 8, my lord, last 3 lines at CH-16, para 8, my lord. The Labour Court is also competent to construe a settlement, award, or a statute under which the right is claimed. Para 8, my lord, that is in my
WA 2588.
Management of International Travels versus Devraj.
Yes.
That one. At page 16, my lord.
Yes.
In page 16.
It's again quoting Ram Keval.
Yes, Ram Keval. That has been upheld by our own division bench, my lord. Upheld in the sense relied upon, and I'm sorry, relied upon, and same thing has been extracted, my lord, and said under a statute also it is available. And in fact, the facts of that case, it was in respect of overtime wages, which is covered under the Factories Act. There was no other agreement, nothing else, and the amounts were disputed. The court had full jurisdiction to go into whether I had, if the court comes to the conclusion I have done with overtime wages, if I'm able to demonstration on fact before the under 33C2 before the Labour Court, I'm entitled to it because the right to get it flows from the Factories Act.
Yes.
Similarly, in respect of leave salary, actually, my lord, here in my case, the leave salary was rejected. I have not challenged the order, but leave salary also is covered under the Factories Act because for every 20 days I work, 1 day I get as earned leave, but the court has rejected it anyway. That's not open because I have not challenged the order. My leave salary claim has been rejected by the court. So, my lord, then my lord, this was, my lord, at page 32, my lord, 2 more judgments I have quoted, my lord. Page 32, in respect of Arkal Govindraj, this I have quoted for the simple reason, this one and the next judgment, for the simple reason, who is a workman under ID Act? My lord, the courts have very repeatedly over the period of long period they have stated is, what is the basic and predominant nature of work? Don't go by the salary, don't go by the nomenclature, because in private companies, any name can be given. You can call him an executive, you can call him anything. But what is the basic and predominant nature of work you find? And even if there is some additional work, then even that supervisory work, it will not change the nature of that he comes under the definition of 2 years of the ID Act is what the court said. That questions are there at page number 33, para 7. Page 33, para 7.
Yes.
My lord, from the middle, my lord, last 5 lines. In other words, the dominant purpose of employment must be first taken into consideration, and the loss of the additional duties must be rejected while determining the status and character of the person. Appreciation of evidence of Labour Court cannot be faulted, but it landed. That is what the court said. That is the principle laid down is what is the basic and predominant nature of work. Some additional supervisory work is done, also still he remains a worker because it is only an additional work and not his predominant work. That is what the courts have gone into saying. At page 36, that is being reiterated in this judgment by para 17. The test that one must employ in such a case is what is the primary, basic or dominant duties, nature of duties for which the person whose status is under inquiry was employed. A few extra duties would hardly be relevant to determine his status. The words like managerial or supervisory have to be understood in their proper connotation, and their mere use should not detract from the thing. So it's not the nomenclature, it is the basic work which you are pursuing. If there is any evidence to show that I was managing people, I had the discretionary powers, financial powers, then I go outside the purview of 2S of that. Otherwise, all of us will come under the purview of ID Act. Deliberately, the legislatures have kept the definition wide so that there is some forum for them to agitate. Otherwise, they will have to go to civil court. That's all. Only the courts will change as far as the dues are concerned. That's all. Not that.
Remedy doesn't go away.
Yes, ma'am. And then in Mahajan Boral Company, my lord, it has taken into consideration all the previous judgments and given its on the same aspect, my lord. Which at page 39, my lord, para 7, middle portion, that what is extracted in page 39. Fourth line, my lord, the extracted portion from after giving full. Yes. This is of Maini versus Karuna Sahu. Such questions is required to be determined in reference to the facts and circumstances of the case and materials on record, and it is not possible to lay down any straitjacket formula for which to decide the dispute as to the real nature of duties and functions being performed by the employee in all cases. And the courts have gone through and said, my lord, here that it's a question of finding of fact and not of law. Of course, it could be said as a mixed question of fact and law, and the courts have said that finally, the 226 is a finding.
Para 10.
But yes. And then, my lord, as to the judgment, you know, just point out a few like paragraphs of the order parts, judgment part by the court, my lord, where the considered order, my lord, the entire evidence was taken, the rival contentions were taken, my lord, and reasons start from page 24. It's just the facts which have been elicited, my lord. My lord, they produced 2 salary registers from 2011 and February 2013. These 2 things. At para 13, my lord, page 27.
Yes.
The respondent institution produced 2 salary registers from March 2011 and March 2013. On perusal of the entries, exhibit 31 and 32, commencing from March 11 till 2014, it is apparent that the salary has not been paid to the appellant as per the rate fixed under A4. Then, my lord, at para 14, they have discussed that they are not, as submitted by my learned counsel, my lord, that they were not able to produce with regard from 2000 to 2011. And the court had said the employer is required to establish that there is no short payment and non-payment. Here, the respondent is the employer, and burden is on him to show that there is no short payment and non-payment of salary. In the order of discharge, such burden, the respondent has not produced any record. My lord, it's not only the registers that will show, reflect that, my lord. They could have proved the same through so many bank statements or the receipts or whatever it is they could have produced. If they wanted to contradict me on, if I have made a false claim, they could have done it and contradicted me because with bank statements or with whatever records they could have had, not only the registers. They, other than denying, my lord, they have not even given what they have paid or what they have stated. They have not. Only a blank denial of everything is all that they have. Even the objection statement is only a blank denial of what we have stated in the application has been denied. They have not come forward and said what they have done. They have not come forward with the facts, which is playing only safe, my lord, is not the right, especially when a workman is involved. They should have come with better because he's not most equipped, and very often he may have not have in possession all the records to prove his case. And my lord, many of my claims the court has rejected. I just point out, my lord, because it's a considered balanced order.
Gratuity is rejected, your vacation leave is rejected.
Vacation leave is taken away. Then even for the 2 months, though they have paid only what the wages they have paid, the difference they have not paid. But those 2 months also is being removed. If your lordship sees the operative portion on page number 36, my lord. 36. 55. The applicant already received part of such salary at exhibit A15, and therefore the amount already paid has to be deducted, and remaining amount is to be paid by the respondent, the applicant. They are disallowed for 2 months. For January to December 2008, rejected. So many of my claims for the leave and for gratuity, they had claimed in the middle of the proceeding. They said, I cannot go into it. No pleadings are there. That is also rejected. But what they have still not paid the gratuity or whatever it is. When he finally was removed from service, they ought to have paid everything together, my lord. And if your lordship gets the first cursory look of the statement of calculation, how they have defaulted in paying the salaries differences. They were paying part amounts, not even their whatever amount they have decided to pay, they should be paying consistently. Even that has not been paid. Your lordship is just looking to the statement of calculation from page 68 onwards. It is till 2011, my lord. It was under the older management. There also there was less payments. Some for 1 month they did not pay. Again, it was highly irregular, which I have stated in my application itself, my lord. For the year, my lord, it starts. I've given the calculation from 2000, 2001, 2002. What they have, I ought to have been paid, and what was actually paid is there now. So these records, my lord, these are supported by record. Otherwise, they would have brought the record and shown that you are wrong. They could have very easily contradicted me. My lord, after 2011 also, your lordship may see under the new management. That is at page 70, it starts now. Page 70. 5,250, 5,000, then it is gone to 6,500. Then, my lord, on the next page, 71, 6,500, it has gone to 8,000 actual payment. Then, my lord, for in 2013, suddenly in May, they pay 1,032. Then in June, 4,800. I have also claimed only for the days I have worked. In the left side, what has to be paid is also reduced because of whatever reduced days I had worked. I have made a fair claim, my lord, and it's only the difference which I have claimed, which I am entitled to, my lord, along with interest, which they ought to have paid by confirming the order, my lord. He's also 76 and he's not able to file further petitions. That is why. And
just 2 points. I've been informed that the respondent has in fact filed a claim again for gratuity, so it's rejected here. It's currently pending for the.
It has not been rejected here. They said it cannot be considered. That's all. Before the authority, ultimately he has to get his gratuity, which is entitled to under law. So I only advised him, said, if this is not the appropriate forum, you go under the Payment of Gratuity Act and make a claim in the. If he is entitled to his gratuity, if he has completed his 5 years of service, he is entitled to it at the rate of 15 days wages for every completed year of service, which he can get it adjudicated in the court.
I'd only like to reiterate 2 points which I
Don't reiterate. If you have any reply.
The question of him being an administrative officer, the Lordship could go through the award of the Labour Court. The Labour Court has held that he has proved that he's been promoted to the post of an administrative officer. There's no finding to the effect that he continues in his role as a clerk. And that portion.
What Mr. Srinivasan is saying is, the designation may be.
I agree.
But the role being discharged is that, and the designation has been given only to increase the pay. That is his.
But it is his own claim that he was entrusted with the entire office money. And secondly, Your Lordship, we have produced the salary register, which was pointed out by Learned Counsel in para 13. We did produce the salary registers from the years of March 2011 to February 2013. And in the award of the Labour Court, it says that on perusal of entries in exhibits A31 and A32, that is the salary registers from 2011 to 2013, page 27, para 13.
Where is it?
No, I haven't produced those two, but if I could just read the portion from the award, it says that on perusal of entries in exhibit A31 and 32, it is apparent that the salary has not been paid to the applicant as per the rate fixed under exhibit A4. Exhibit A4 is the document that we have disputed. I've produced it at page 58. That is the document under which he claims his salary has been enhanced to 5,000 plus 1,000 increment per year. Now, the question, Your Lordship, which rises is whether an executing court has the power to investigate and look into this document that I have already claimed to be a fraudulent document. All the judgments that have been produced by Learned Respondent Counsel are judgments wherein and there was a pre-existing award or the right flows from a statute. In this present case, in the petition that he had made under section 10 before the labor officer, he has not produced this document at all, this memo dated 2007, on the basis of which the award of the Labour Court says that we have not paid the salary as per the amount mentioned in the memo. But this document was not been produced before the Labour officer.
Which one is not?
The memo stating that his salary has been increased to 5,000 and he's
It has
entitled.
been marked as exhibit A4.
That has been produced before the Labour Court, Your Lordship. But in his earlier petition before the Labour officer, he has not produced this document.
We are concerned with what is here in 33.
Please, Your Lord, but it is my submission that the Labour Court does not have jurisdiction, hence to look into this application under section
That
30.
you already made. That submission you already made, we'll deal with that. Anything else?
It's an appreciation of fact, my lord, evidence.
No reply to repetition. The petitioner is before this court. The petitioner employer is before this court seeking for the following reasons. The Labour Court, by way of an order dated 11 January 2022, in application number, the Labour Court DK Mangaluru, by way of order dated 11th January 2022, in application number 1 of 2014, had passed the following order, page 35. The respondent work has filed the proceedings in application number 1 of 2014, claiming that he had been appointed as assistant constable from 1860,000 and monthly salary of 53,000. And had carried out his duties from 22 to 64,000. The founder of the petitioner, being Dr. H.C. Kaveri, her husband and sons were the other members of the executive body. The petitioner was running 2 institutions by name School of Nursing and Paramedical Services. It is alleged that Dr. H.C. Kaveri was a proprietor and medical practitioner of Kiran Nursing Home. She expired on 16/3/2011. Thereafter, the management of the petitioner was reshuffled and a new committee was formed to review of his guidelines. It is contended that the workman had not been paid full wages from the year 2000 as per the appointment on 18/6/2000, which has been marked as Exhibit A1. The memo dated 1/6/2007, dated Exhibit A4, whereunder a salary was fixed at ₹5,000 per month with effect from 1/6/2007. He being entitled to additional increase of ₹1,000 per annum, commencing from January of the year till his services in the institution. On the said basis, a memo of calculation was submitted by the workman, calculating placing on record the amounts to be paid and the actual payment made, and thereby deriving the balance amounts due. And the workman sought for direction to the employer to make payment of the said amounts under Section 33(c)(2) of the ID Act 1947. On service of notice, the employer entered appearance and submitted that the employer has come into the picture recently. The employer does not have any documents in its possession. Further stated that the workman was working in administrative capacity and as such could not claim the status of a workman under Section 2S of the Industrial Disputes ID Act. It was denied that there was any salary due and payable by the employer to the workman. The claim made by the workman was denied as false. It is contended that the employer has duly paid the due salary of the workman. It is only the managing director of the employer who is having power to make appointments and issue promotion order. The order at annexure Exhibit A3 not having been signed by the managing director. The same was not proper document. All other claims were denied. It is on the said basis that the said rival contention that the labor court took up the matter and decided partly in favor of the workman by passing the directives as official. Ms. Kaveri Timaya, learned counsel appearing for the petition, it is agreed by the employers before this court in the above matter. Ms. Kaveri Timaya, learned counsel appearing for the employer, would submit that in the present case, the respondent is not a workman within the meaning of Section 2S of the ID Act. Even according to the workman is claiming to have been appointed as an administrative officer, which is in the management cadre. He was discharging the said activities which would disentitle him to claim himself as a worker. That the claims which have been made have been denied by the employer, and as such denial, the Labour Court, acting within the purview of Section 33C2 of the ID Act, could not have given a finding on disputed question of fact. The Labour Court ought to have dismissed the claim made by the workman and relegated him to a civil court. The Labour Court has in fact adjudicated disputed claims which was not permissible under Section 33C2. And in this regard, he relies upon the following decisions. 2000. (22) 1 UC 193. The para numbers are the same in the actual judgment, madam?
Please.
2022 2 LLJ 53 bracket SC. More particularly para 7 thereof.
I'm
Relying
sorry,
on the-
I'm sorry to interrupt. The paragraph numbers are the one from the Manupatra side.
Is it the same as? The 7 which is also. Para 7 thereof, which is reproduced here in the 30. Relying on the above, she submits that where the very employment as a salesman by the employer was disputed, the Labour Court would not have the power under Section 33C2 to decide a claim made by such person whose employment itself is disputed. Relies upon 2001 1 SCC 73, more particularly para 9 thereof, which is reproduced here. Relying on the above, she submits that the benefit which is sought to be enforced under Section 33C2 is necessarily a pre-existing benefit or one flowing from a pre-existing right. In this case, there is no such pre-existing right, inasmuch as inasmuch as Annexa A3, on which basis the workman has laid a claim, has been denied by the employer. Rise upon 2018 3 LLJ 611 bracket Bombay, more particularly para 4. By relying on the above, she submits that the Labour Court has travelled beyond what it could adjudicate under Section 33C2. Therefore, the impugned order passed by Labour Court is required to be set aside. A.J. Srinivasan, learned counsel appearing for the workman, would submit that the claim of the workman is workman, apart from several other documents, is based on Exhibit A1 and A3. A1 being the appointment letter and A3 being the fixation of enhanced salary increment. A4, A3 or A4?
Page 58, it is A4.
A4. A4, sir.
Previously also it was
A4. A4. The fixing of the salary at rupees 5,000 with effect from 1/6/2007, with the additional increment of rupees 1,000 per annum, commencing from January of every year. His contention is that from 18/6/2000, the full salary was not paid in terms of Exhibit A1, where under the amount of rupees 3,000 was to be paid as monthly salary. And in terms of exhibit A4, the agreed sum of rupees 5,000 had not been paid, nor have the increments been paid on time. This being a pre-existing document prior to the claim made by the petition, by the workman has calculated the same in terms of exhibit A15 and placed the same on record before the labor court, giving details of the payments required to be made, the actual payment and the balance due. This has been taken into account by the labor court, and as such the finding of the labor court being proper and correct is not required to be disturbed. In the alternative, he further submits that the statements having been placed on record by the workman in terms of exhibit A15, it was for the employer to have countered and or rebutted the evidence on record. The same not having been done, a mere denial by the employer would not inure to the benefit of the employer. The amount claimed is bona fide, calculated on the basis of exhibit A1 and A4, which has been taken into consideration by the labor court. He submits that the pre-existing right under exhibit A1 and A4, being in terms of documents, the same could be adjudicated in terms of section 33C2. The adjudication is basically calculation, which has been done by the labor court, and the claims made contrary thereof by the employer not having been countenanced by any evidence on record. The order passed by the labor court is proper and correct. In support of his contention, he relies upon AR 1964, SC 743, more particularly para 5 thereof, 5, 9, 11, 16, 18, 19 thereof. By relying on the above, he submits that the adjudication of a claim to the benefit made by the workman is permissible under the Act. And can be invoked by a workman who is entitled to receive from the employer a benefit which is specified. He submits that the earlier under section 20, in the erstwhile section 22, there was a restriction and or further requirements to be removed. But in terms of section 33C2 of the ID Act 1947, those restrictions have been done away with. Under section 22, it was only the basis of a settlement. But under section 33C2, a speedy remedy has been provided to individual workmen to execute their rights under pre-existing agreements in contradistinction with that under an award or a settlement. He submits that the labor court under section 33C2 can determine and compute the benefit in terms of the money and necessary inquiry could be carried out for that limited purpose. He relies upon the decision in which 1997 2 LLJ 203, more particularly para 4 thereof. By relying on the above, he submits that under section 33C1, the requirement for an award or a settlement, but under section 33C2, the claim of a workman for the benefit to be computed in terms of money, even though that claim is disputed by the employer, can be considered by the labor court. Relies on 2010 LLJ 528, more particularly para 8, where under this court, by referring to the above, he submits that this court has applied the decision in Ram Keval's case and held that the provision of section 33C2 is wider and takes within its purview the case of a workman who claims any benefit which could be computed in terms of money. Just an executing court is competent to compute the dues, and that the labor court is competent to decide on those issues. Relies on the decision of this court dated 31st August 2009 and writ appeal number 2588 of 2009, more particularly para 14 thereof. By relying on the official petition, he submits that even a claim for leave with wages and or bonus could be made under section 33C2. Refers to 1985 3 SCC 371, more particularly para 7 thereof. 7 and 17 thereof. By referring to the above decision, he submits that the primary test to determine whether a person is a workman or an administrative staff, so as to decide whether the said workman would come within the purview of section 2S of the ID Act, would be what is the primary, basic or dominant nature of the duties which are performed by a person. A few extra duties would not be relevant to determine the status of a person to be that of an administrative officer or a workman, as an administrative officer and not as a workman. He refers to the objection statement filed by the employer for the labor court, more particularly para 5 thereof, which is reproduced here. By referring to the above, he submits that the employer is approbating and reprobating inasmuch as the claim of the employer is that because the work, because the post occupied by the workman is designated as an administrative officer, he would not come under section 2S of the ID Act. But in para 5A of the objection, the employer himself has categorically stated that the applicant, that the workman has never worked in the capacity of an administrative officer in the institution, and that he is not qualified to be appointed as an administrative officer of the institution. He submits that the employer cannot take advantage of the same situation, on the one hand contending that the labor court has no jurisdiction on the ground of the workman being an administrative officer, on the other hand contend that he is not the administrative officer and as is not entitled to the monies. This submission made by the employer in the obligation statement inures to the benefit of the workman is the contention. Refers to ILR 1998, Karnataka 172, more particularly para 10 thereof. And submit that the labor court, having come to a conclusion that the applicant before the labor court was a workman, this court, in exercise of powers under Article 226 of the Constitution or 227 of the Constitution, ought not to set aside a finding of fact recorded by labor court. And the said finding on fact is required to be transformed. In rejoinder, Ms. Kaveri Timaya, the counsel for the petitioner, would again reiterate the submissions made, but further submit that none of the ledgers were available with the employer, since the employer is now under a new management. And it is for that reason that the earlier ledgers from the year 2000 to 2010 could not be. However, ledgers post 2011, when the new management took over, has been produced, which has been taken note of by the labor court in para 13 of the judgment, when reference to exhibit 831 and 32 has been made. But merely on coming to a conclusion that there are no payments which are reflected therein, the labor court has come to a wrong conclusion that payments have not been made, when it ought to have come to a conclusion that there are no payments which are due to be paid. But it is on that basis she again reiterates that the petition is required to be allowed, and the impugned order passed by labor court. The point that would arise for determination doesn't matter is one. What are the powers of the labor code, section 33C2, to decide on the claims made by a working, to whether the contention of the employer that there are no dues liable to be paid to the employee would be sufficient enough for the labor court to dismiss the claim made by the workman on the ground that there are disputes between the parties which cannot be adjudicated under section 33C2. 3. Whether the order passed by labor court suffers from any legal infirmity or not. Arguments heard Ms. Kaveri Timaya, counsel for the petitioner, and CH-16, learned counsel for the respondent. The contentions, the facts, contention, and points for determination are dictated in open court. Reserved for judgment.
With your Lordship's permission,
Mr. Kasturi,
I seek your Lordship's leave. Since my learned friend CH-16 is there before your Lordship.
Yes.
Serial number 74, I am filing written submissions.
74, you have filed or you are filing?
We have already served a copy on my learned friend.
Yes.
And we are just filing it before your Lordship. My colleague is in another court.
No, Mr. Mohan.
I think he is there, my Lord.
Yeah, Mr. Mohan Kumar is there.
Oh.
Yes.
No, your Lordship, if he wants to file any written submissions, he can go through this and file.
74.
My submissions will be only 5 minutes after he receives copy.
Written submission, the same is taken on record, where a counsel respondent seeks for and is granted a week's time to go through the same and may file his written submission, which shall be filed on or before 17th, released on 23rd.
Much obliged. Deeply obliged.
40 minutes. ಮಾತಾಡಿದೆ ಸುಬ್ರಹ್ಮಣ್ಯಂನ ತೊಂದರೆ ಇದು after 2 weeks
ಇವಾಗ ಕರೀತಾ ಇದೀವಿ.
ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು.
ಇವಾಗ ಪಾಸ್ ಓವರ್ ಪಾಸ್ ಓವರ್ 2:30 ಇದೆಯಾ? ಆಯ್ತು 40.
ಅದು
40 M settle ಎಲ್ಲೋ
document. I conclude the argument ಅದರಲ್ಲೇ Kashima Academy correct.
ಇವಾಗ ಏನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೀರಾ?
ಅದು ಅಲ್ಲಿ ಅವರು ಅಲ್ಲಿದೆ ಅಂದ್ರು. ಅಲ್ಲಿ ನೋಡಿ ಮೆಮೋ ಇಸ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಕಾರ್ಪೊರೇಷನ್ 230 ಕೇಸ್ ಅಲ್ಲಿ ಇಂಟ್ರಿ ಮಿಲಿ.
ಇಲ್ಲ ಈ 40 ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರು, ಆಮೇಲೆ ನೋಡೋಣ ಅಂದ್ವಿ.
ಆಯ್ತು
ಆಯ್ತು ಬರ್ತಾರೆ ಬಿಟ್ಟು.
ಇಲ್ಲ 40
2:30
is out of station. But this I am told that yesterday, very good. This is of laying the.
Who is the person laying the?
This is Karnataka Power Grid Corporation. Your Lordship may kindly permit me to imprint that corporation. My Lord,
I see in Nageshri that council who had accepted notice for respondent number 1 to 3 submit that it is not the Karnataka Power Transmission Corporation Limited who is drawing the lines and constructing the towers. It is the Karnataka
Power Grid Corporation.
Power Grid Corporation Limited, which is the
as a respondent number.
oral request made by counsel for the petitioner is accepted. Karnataka Power Grid
Corporation permitted as 6th respondent.
It is brought on record as respondent number 6. Who is the standing counsel?
Pardon?
Shri Joshua Samuel, Maruti, standing counsel, is directed to accept notice for the implemented respondent number 6. Counsel for the petitioner to serve a copy of the petition along with annexures on the said counsel. Released on 13th February at 2:30 p.m. Sorry.
Till then, they are forcibly allowed to
file a petition without even verifying who it has to be filed against. And you want interest.
They have issued the notice, my Lord. These people have been trying to deal with all that. Your Lordship may kindly see, my Lord. Now they are saying.
KPTC and issue.
Annexure J. Your Lordship may kindly see Annexure J. My Lord, this is from the Deputy Commissioner's office.
KPTC ಏನಾದ್ರು ಹೇಳಿದಾರಾ?
Yes, my Lord.
ಎಲ್ಲಿದೆ KPTC?
Kindly see the first respondent.
ನೀವು ಮಾಡಿದೀರಾ? Is there any document to show KPTCL? You have not even made it properly. Wait till 13.
And all that. Till
we have only now brought them on record. Please wait. You have filed it against the wrong person.
R5
the R5. Joshua Samuel is directed to accept notice for respondent. Observe mine.
But it's 13th, 14th.
If they have demarcated it and paid the compensation, we won't be passing any interim order. 13th.
They are not demarcated, nothing.
Let us hear the
laborers come and they start digging.
ನಿಮಗೆ ಬೇರೆಯವರೆಲ್ಲ ಬಂದು ಹೇಳಿದ್ರು, ಆಮೇಲೆ ನೋಡಿದ್ರೆ it had been done. We vacated interim order. It's a project which is happening. So you did not even know who was doing it. Let's have it on 13 and let's see.
All the documents. 14th.
Have it on 14th. Your Lordship, have it on 14th. Senior colleague is there. Your Lordship, have it on 14th, my Lord.
13th ಬೇಡವಾ?
13th ಬೇಡ.
14th ಹಾಕೊಳ್ಳಿ.
14th at 2:30.
My Lord, in the reply by the Tahsildar, they have mentioned, my Lord, it is they have said that, my Lord, KPTCL is doing it, my Lord. And they are now in the field with JCB and all other measurements. Till then, my Lord, you may kindly protect, my Lord.
Page number. Page number.
Pardon, my Lord. In the reply by the Tahsildar, Mr. Bhatt is having the paper.
Page number.
To my legal notice, my lord, the Tahsildar has replied, my lord.
Yes, Mr. Bhatt. Page number.
Tahsildar.
Annexure F, my lord, annexure F.
Annexure F.
Annexure
But they
F.
say there is a direction by the deputy commissioner to finish it off, my lord, as early as possible.
Where is KPT?
So they are saying nothing.
Acharya, where is KPTC's name is a question. Deputy commissioner reply.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು ನಮಗೆ ಅದನ್ನ ಎಂತದ್ದು ಹೇಳ್ತಾ ಇಲ್ಲ ದೇ ಆರ್ ಡಿಸ್ಗೈಮ್ ದಟ್ ಈಸ್ ವೈ ಮೈ ಲಾರ್ಡ್ ಬಿಕಾಸ್ ಯುವರ್ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್ ಮಿಸ್ಟರ್ ಸಿಂಗ್ ಈಸ್ ಇನ್ ದ ಸ್ಪಾಟ್ ಅಂತ ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂಡ್ ದೇ ವಾಂಟ್ ಟು ಫಿನಿಶ್ ಇಟ್ ಅಪ್ ಆಸ್ ಅರ್ಲಿ ಆಸ್ ಪಾಸಿಬಲ್ ಮೈ ಲಾರ್ಡ್.
We'll take it up on 14.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
Number 69, 70, adjourn, 71.
Appearing for the petitioner lordship.
Yes.
Yeah.
Senior Barbata.
We had filed an IA and we have also received the set of objection in that. We'll argue on this matter, your lordship. Next date of hearing will do it.
71, it is submitted that the arguing counsel for the petitioner is not well. Hence released on. The application.
Now on the direction, these people had forgone their retired benefits and also settlement because the company would revive. All these people, yeah, they were all forced to take VRS subsequently.
24. 24.
Much obliged.
72. Subramaniam.
Really, yeah, appearing for the petitioners. On the last day of hearing, Anand was expressing that we can go for a settlement, and I don't know whether it was also some possibility of settlement. Not aware of that.
My lord, senior is unwell today, my lord. Next date of hearing, whatever is there, we will submit, my lord.
Whatever is there on the settlement model.
Yes, my lord. Senior is not available today.
So both the councils submit that there is a possibility of settlement, and if a short accommodation is granted, they'll endeavor to report.
Submission, my lord. From our side, senior did not confirm any settlement, my lord.
Or illa anta idare.
Then we'll go for we'll make our arguments here.
I will just adjourn it.
Yes, my lord.
At the request of the councils released on 24th.
73. Short accommodation is required.
24th.
So the 24th August.
For the petitioner released on 24th.
Much obliged.
74 adjourn, passport matter. Serial number 16. Girish Bandare and corrected matter.
Last, your lordship, kindly lord. I had made a mention, my lord, the difficulty of shifting from the established system of my lord NIC to any other mode. And your lordship had suggested something which I had communicated. But meantime, what happened, my lord, already they have restricted, or rather, my lord, all the system only to the land acquisition cases. So there was perhaps a communication gap. They thought in different way. I said that is not it is not only meant for land acquisition matters. Generally, it has to be done to all the system itself.
Yes.
As they have done for the appointing nodal officers in each of the department, irrespective of the department. They have appointed nodal officers for every department. So that suggestion, my lord, has been accepted, my lord, but unfortunately, the person who is doing it now, but he is held up in the drone survey matters. So he can't take up all the matters because my lord, he is one officer who is well versed.
More people to do this, Mr. Krishna.
But unfortunately, my lord, I have to admit the fact, my lord, the kind of enthusiasm being shown from this side to that side, my lord, if it is transmitted in the same way and accepted in the same way, things should have been much better. That is not happening. So sometime more time may be granted. As of now, some workflow chart has been prepared. Which I also don't understand how it is.
To get into implementation.
It is being done, my lord. For the now presently, my lord, they have prepared one workflow chart for the
functional requirement ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಫಂಕ್ಷನ್ ಆಗಿಲ್ಲ. ಅದ್ರಲ್ಲಿ ಅವರು ಒಂದೊಂದು ವರ್ಷ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಟೈಮ್ ಲಿಮಿಟ್.
1 ವರ್ಷನಾ ಫಂಕ್ಷನಲ್ ರಿಕ್ವೈರ್ಮೆಂಟ್?
It is just for your lordship's reference, how they have. Sent to me.
That is not.
And I told them that is too much because although actually he has sent, but nobody was there to tell me what is that.
No. This must be the.
ನಂಗೆ ಅದು ಅರ್ಥನೇ ಆಗಿಲ್ಲ ಅದು ಏನಂತೆ.
This must be the time limits under the act for those notifications.
Correct. ಅವ್ರು ಇದನ್ನೇ ಮಾಡ್ತಾರೆ ಅಂತ
Not for them to do it.
ಅಲ್ಲ ಅವರು the officer who has sent me, I could not speak to him, but he said this is the method they are following is this one ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ನನಗೆ ಅದು ಏನು ಅಂತ ಅರ್ಥ ಆಗಿಲ್ಲ ನನಗೆ. I need to speak to him personally.
ಯಾವಾಗ ಮುಗಿಯುತ್ತೆ ಡ್ರೋನ್? Drone survey ಯಾವಾಗ ಮುಗಿಯುತ್ತೆ?
Drone survey malad is actually malad the whole year, but they are training the ADLRs and ADLRs.
ಯಾವಾಗ ಮುಗಿಯುತ್ತೆ?
That is the whole year.
Training ಯಾವಾಗ?
Training malad 2 weeks, 10 days. ಅದು already start ಆಗಿದೆ, 3 days ಆಗಿದೆ.
Date ಯಾವಾಗ?
10 days. I mean, when I spoke to him, it is 3 days ago. He said it's
7 more days. So we have it on 22nd.
Please.
By then you will know what it is.
And I also need to understand what is that he has sent. I could not make out.
This is about the time limits under the act and September. Admits that the concerned person handling the project is otherwise held up in training the ADLRs in carrying out drone service, and as such, he will not be available for 1 more week. And released on 22nd at 2:30 for reporting further compliance.
Serial number 20. Karnataka.
Prashant Chandra. They've been reinstated. They're saying that they've been
That is another malad big disaster. But what happened was, this honorable court was pleased to pass an order. Twice the order was passed.
Yes.
Once they were directed to reinstate him in this proceedings, they did not do. Thereafter, my lord, again an order was passed. Then my lord, on the prescribed day, the workman went and reported for duty. He is a driver. For 3 days, he was made to wait, and no work was given to him. Fourth, I'll find them. Fourth day, what happened? They say that however, how much he has to travel 100 kilometers from his place to the Udupi. He did that for 4 days. Fourth day, they said, we are only going to pay you 1,000 rupees per month. Irrespective of what the court says, because there is no order as by the High Court now for payment of anything. He was totally went in trauma and depression. I have fought the case for nearly 25 years. And if this is I am going to get after 25 years of the fight in the court.
Please inform Dr. Nandakishore that these are the submissions made.
I'll file the affidavit, my lord. Morning, that is the reason I sought for time, but however, my lord, my friend was not insisting.
We wanted to know what is happening because Dr. Nandakishore said nothing survives, application could be disposed of because they have reinstated.
Then, my lord, there is no compliance at all. This matter, my lord, from right from labor court
when
to
you file,
kindly have it next time, any day, I'll file it.
submission of the letter counsel for the respondent is that the workman has not been reinstated.
No, I don't say that. On record, they have done it.
Reinstated in a proper and effective manner, in as much as when the respondent workman is called for the work, he was told that an amount of ₹1,000 per month would be paid. Since there is no particular direction which has been issued by this court. Counsel for the respondent seeks for and is granted a week's time to file his affidavit. Please, to that effect. Copy thereof to be served on the counsel for the petition on or before 17th, released on 22nd for the say of the petitioner.
I will do.
We feel these are very serious allegations.
Serial number 27.
None appears, though called twice. Released on 23rd February.
13. Yes, any order? Corresponding paper week's time.
Counsel for the petitioner seeks bond is granted 10 days time, released on 28th February.
Obliged. 36. Dhananjaya.
But appear for respondent in this case, my lord.
Yes. Of the counsel for the respondent released on 28th February.
Please.
40. Yadi Narayan Swamy and connected message.
We were making some submission.
Weeks date fix ಮಾಡಿ.
Yeah. The request of the counsel for the employer released on 2nd March.
44. Yes, Satyanarayana Shastri and connected matter.
44. None appears, though called twice. If none were to appear for the petition on the next date of hearing, the petition will be dismissed for the non-prosecution released on 21st February.
57.
57.
Satish Chandra.
None appears, though called twice. Dismissal 21st.
58.
We are for the respondent, my lords.
Hearing for petitioner, paper week's time.
The current counsel for the petitioner seeks for short accommodation released on 28th February. If arguments is not advanced on that date, the petitioner will be liable to be dismissed for non-prosecution.
Much obliged.
59.
Same order.
Same minor.
Same order.
63. Gaten Hansi and connected matter.
Petitioner, my lord, we have served the copy to the other side. My lord, on the order dated 12/4/2022, this court has mentioned that learned counsel for the respondent submits that the petitioner has not even deposited the compensation amount awarded by the labor court. So there is a mention by this court that about the respondent's contention. So there is no direction.
No direction. We'll issue the direction.
The case
that itself is a direction.
case of underperformance. That's what they have stated. I have
Challenge the very order of.
We'll give them 1 week's time to deposit. You want a positive direction, we'll issue positive.
We have challenged the very order of the labor court.
Yes. But this is the order. Until then you have to deposit. Also submit that copy of the petition along with annexures in WP 468630 of 2021 has been served on the counsel for respondent, which he confirms receipt thereof. This court, while order dated 12/4/2022, had observed that the amounts ordered as compensation has not been deposited. He said observation itself was sufficient for the petitioner to have deposited the money. Today on inquiry, the counsel for the petitioner submits that there was no positive direction. The amount has not been deposited. Hence, a positive direction is issued today, directing the petitioner to deposit the compensation amount within a period of, how much is the amount?
3 lakhs with 18% interest is
10 days. The deposit will be made on or before 22nd, released on 24th.
Along with interest may specified, otherwise they'll rep only the 3 lakhs. It was 3 lakhs plus 18% interest from the date of publication of order.
Whatever the amount is.
Yes.
By which date the amount of compensation, applicable interest shall be deposited.
65.
Appear for the respondent in 65, my lords. And connected matters, I appear for the petitioner.
The 17B applications may kindly be taken up, my lord. These are a set of 10 workers, my lord. 10 in 5 matters I have filed 17B applications. 65.2, 3, 4, 6, and 7.
Yes, my lords. But I filed objections in 3 of them, my lords. And remaining 2, I have no gainful employment records of theirs. So the 2 I have not filed 17B, I am ready to pay, my lords.
Which one are those?
65.2 and 3, my lord.
65.3, you have not filed objections.
65.2 and 3, I have not filed objections.
You pay 17B wages.
Yes, my lords.
You don't want
The
to
remaining I have filed objections.
you don't want to reinstate them.
No, my lords. No, that will be subject to the final order of the writ petition.
We'll reinstate subject to that. Or you want to pay free money, it is good.
No, my lords. 2022 matter, my lords.
So you want to pay for another 5 years and then decide. You're paying money, get some work done. They'll also be happy working something there.
My lords, they're actually not our workmen. My lords, they're contractor workmen.
The counsel for respondent submits that the petitioner submits that since she was not able to trace out details of any gainful employment on part of the workman, especially 10141 of 2022 and 10160 of 2022, the employer is willing to make payment of the 17B wages
From the date of the filing of the petition.
the date of the passing of the award and 1 month.
My lords, from the date of the filing of the writ petition, my lord, 17B.
From the date of the award, madam. From the date of the award and 1 month thereafter. Only 1 month you get.
Bank and Islamia Institute if necessary, my lord.
My lord, 17B may kindly be looked into once again, my lords, please.
The Supreme Court has held it is 1 month after the award.
Okay, my lords.
In compliance
Because
with-
17B very clearly says from the date the affidavit has been filed.
We will say in compliance with the judgment of the Honorable Apex Court in Dena Bank versus
Yanam Bank was in Khansham, 2001, 1 SEC, 2270.
2270. What about the others?
Argue, my lord. Some citation. The objection.
Filed.
My lord.
Ready for argument?
Yes, my lords. My lords, it may be had on Monday. Senior will argue. He has just instructed me this much, my lord.
You're very frank and forthright, so that is good.
Actually,
Have you served the citation?
citations, they have given their citations to me.
Both of you have exchanged.
Yes, my lord.
Both the counsels confirm having exchanged their respective citations that are counsel for the petitioner seeks for and is granted 3 days time to make the submission released on 14th at 2:30 p.m.
Much obliged, my lord. My lords, one more submission, my lords. I have an interim order in my favor in the connected matters. It may please be extended.
Order earlier granted is extended.
Much obliged.
It is in water.
Yes, madam. Ms. Rupashri.
Yes, my lords. I appear for the respondent, my lord.
What are the
My lords, this also may be had next week. Somshekar sir is not there, my lords.
The thing was what had happened on the last date of hearing. The lordship had asked me what was the amount you are willing to settle the matter. We had offered 7 lakhs. Mr. Somshekar, the senior counsel, offered 4 lakhs. In between that.
4 and 7.
Somewhere in between.
Mr. Srinivasan is asking for 7 lakhs, you are offering 4 lakhs.
Somewhere, what has happened, my lord, in this case?
It may be had on Monday. Somsekhar sir will be there on Monday, my lords.
How much are you willing to negotiate? Then Somsekhar sir will negotiate later.
My lords, he's the one who's handling the matter. So that's the reason I have to get instructions from him.
You are willing, my lord, to compromise from 7 also. Because, my lord, what has happened in this matter?
How much are you willing to come down?
Lord, 6 will be very reasonable, my lord. That would be.
Mr. Srinivasan has come down to 6. So you will go up to 5. So we'll make it 550.
Yes, my lords. I'll convey this to Somsekhar sir.
I was offered before the labor court. The workman did not accept.
5 was offered before the labor court.
It went up to writ appeal, my lord, and then it got remanded to the labor court.
Then you should close it at 6.
So that is why
It is offered 5 in the labor court, 6 you should close it. Tell Mr. Somsekhar, let us see what he says.
Much obliged, my lords. I'll definitely convey.
Get instructions from your client and you'll have it next week. If you have the DD and joint memo, we'll close it.
Please, my lords.
Both the councils submit that there's a possibility of a settlement being arrived at. If a short accommodation is granted, they would endeavor to report settlement. Relist on 16 at 2:30 PM under the caption reporting settlement.
Much obliged.
Group number 2. Serial number 1 to 4 adjourned. Serial number 5. Government advocate.
Out of the labor court for reinstatement, the workman has superannuated, and I have to find out whether he has been reinstated or not.
PGA seeks for and is granted 10 days time to verify if the workman had been reinstated, since as per the age of the respondent, he appears to have superannuated. Relist on 27.
Serial number 6.
My lords, I appear for the respondent and serial number 6, my lords.
Raghavendra. None appears for the, you are ready?
My lords, kindly a week's time may be granted, my lords.
None appears for the petitioner. Let it counsel for respondent seeks for a week's accommodation. Relist on 28/2.
Much obliged.
Serial number 7 to 9 adjourned. Serial number 10.
It did reach.
I am for the petitioner workman.
Kanikaraj. Mr. Kanikaraj. He is not there. Shikhar ಬಂದಿದ್ದಾರಾ ಕನಿಕರಾಜ್ ಇಲ್ಲಿ? ಫಿಸಿಕಲಿ ಬಂದಿಲ್ಲ. Not
I would argue in his presence Monday.
Then though counsel for the petitioner is present and ready to address his argument, none appear for the respondent. Relist on you can take a chance on 16.
16 Miller.
16.
16 is Thursday. 17th Miller.
17.
I'm okay. If it comes on list, I may have a better chance.
It will come in list one.
That's okay.
Serial number 11 and 12 adjourned. 13. CH-16 and corrected matter.
Hearing for petitioner. Refer week's time, my lord.
Counsel for the workman seeks for a short accommodation. Relist on 16th March.
14. SB Mukandappa.
Petition in this case, kindly have come next week, Miller.
Week alla idella March. Request to the council for the petitioner relist on 16th March.
15. L. Shekhar.
Bandari ಅವರು.
Your Lordship, I appear for on behalf of Harish Bandari, Your Lordship. Even this is the case of the unauthorized absentee, Your Lordship. It may be posted on 16/3, Your Lordship.
Both the council submit that there is a possibility of a settlement being arrived at. Released on 16 under the caption reporting settlement at 2:30.
Much obliged, Your Lordship.
Serial number 17. SP Mukherjee.
My lord, in this case, my lord, I am already deposit the 50% of minimum wages, my lord. It may be really settle ಆಗಿರ್ಬೋದು, so I will take instruction from my client, my lord.
That counsel for the petitioner seeks for and is granted. ಎಷ್ಟು ದಿನ time ಬೇಕು Mr. Naveen?
2 ವಾರ ಬೇಕು ಸರ್, 2 weeks.
Under 2 weeks time, released on 7th March.
ಆಗ್ಬೋದು ಸರ್.
18. Government advocate.
18th, so I speak for 2 weeks time.
Any case, well,
This is the same reinstatement order, my lord. But he is not.
statement ಆಗಿದಾರಾ?
Respondent. Israeli, I don't have any instruction from my client also, my lord. After award passed by the labor court, whether he is a registered or not.
Both the counsels seek for and are granted 2 weeks time to verify if the workman has been reinstated or not. Released on 7th March.
ಆಗ್ಬೋದು.
Serial number 20. KB Narayan Swamy.
At the request of the counsel for the petitioner, released on 16th March.
Serial number 1. ಒಂದೇ ಆದ್ರೆ ಬರೀ ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ ಫಸ್ಟ್ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ ಒಂದು ವಾರ ನಾಗರಾಜ್ ಆ ಕಡೆ ಫೈಲ್ ಎಲ್ಲ ತುಂಬಾ ಇದಾವೆ. ಇತ್ತು ಇವಾಗ ಉಂಟಲ್ಲ
30 ಕರೀಲೇ ಇಲ್ಲ ಮೇಡಮ್. 36 ಕರೆದ್ರಿ.
ಕೇಳಿದ್ದೆ ಯಾವ್ದೋ ಮಧ್ಯಾಹ್ನ
34.
ನೀವು ಮಧ್ಯಾಹ್ನ ಕೇಳಿ 34 ಅಲ್ಲ?
ನಾನು 34.
34 ಬೆಳಗ್ಗೆ 10:30ಗೆ ಟೈಮ್ ತಗೊಂಡ್ರು. 36 ಕೇಳಿದ್ರಿ.
ಓಕೆ ಮೇಡಮ್. 34
ಮುರಳೀಧರ್ ಅನ್ನೋರು
ಅವ್ರ ಟೈಮ್ ತಗೊಂಡ್ರು.
ಬೆಳಗ್ಗೆ 10:30ಗೆ ತಗೊಂಡ್ರು.
ಈಗ ಡೇಟ್ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಡೇಟ್ 24/2. ನೀವು 36 ಅಂತ ಕೇಳಿ.
ಓಕೆ ಸಾರಿ. ಇಲ್ಲ ಇವ್ರು 36 ಕೇಳಿದ್ರು. ಸಾರಿ.
ಇರ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ, ಅದೇ ಕಾಯೋ ತರ.
ಹೌದೌದು.
24 36 ಬಂದು 28ನೇ ತಾರೀಕು, 34 26.
ಓಕೆ.
Court officer, serial number 71.
71. Madam, 71/24/2.
Okay.
ಎಲ್ಲೋ